May it pleases your lordship. Lordship, item 28. It is for hearing. Again, when it reaches, I'll mention it, lordship. I'm just informing the court we will be withdrawing this appeal, lordship. I have instruction. So I'm just mentioning later on when it reaches, lordship. Hello, pleasure.
The concept of the other side, I'd like to mention item 32. That can be posted after the vacation.
My lord, I am appealing for the through this conduct. My lord, your matter will be fixed on 24th October.
No, 24th of 24th of
On 7th of November.
My lord, there will be a little difficulty on 7th of November. If my lord, 22nd October.
no. What is the difficulty on
My
set?
lord, I'm on outstation.
Then 14th.
My lord, 5th of November, my lord.
Okay, 5th of November. On request of learned counsel for both the sides, let this matter be listed for hearing on 5th of November.
May I please your lordships? In respect of item number 6, lordship, I have filed an affidavit in opposition, lordships. That may be called on from the
6
6.
affidavit opposition.
That may be called.
May I please, your lordship? May I please, your lordship? I'd like to mention item number 25 from the daily list, of daily hearing. So Mr. S. Botago is with some difficulty, lordship, I pay for passing for the day, lordship. I've taken consent from the people, lord.
Mr. What is your name?
My lord, D. Gogoi, lord.
D. Gogoi, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel, Mr. S. Thakur. The prayer is allowed. The case diary, which is available, shall be retained till next date. When should we fix it? You are on interim,
Yes, lordship, we are on interim.
then before vacation.
Lordship.
Let this matter be listed again on 1st of October.
Interim order may be granted.
Interim order shall continue till next
My
year.
lord. Highly obliged.
24. 24. Yes, what is your prayer? Heard Miss M. Sahu, learned counsel for the petitioner, who prays for an adjournment on the ground that her senior, Mr. N. Jha, is out of station. The prayer is allowed. You are on interim? No. Okay. Let this matter be listed again. CD is there. Scan copy. Scan copy. Let this matter be listed again on 3rd of October. 3rd of October.
May I please your lordship? Lordship, I beg to mention item number 29.
29.
Yes,
Yeah.
okay. I am appearing on behalf of H.R. Chaudhary.
Yes, what is your
Lordship.
prayer?
Yesterday, suddenly his sister was expired. So hence
Okay,
he could
heard.
not appear before this honorable court
Heard
today.
me. What is your name?
A Islam. And kindly the matter may be fixed on 1st of October.
Uh-huh. Let this, it will go after vacation. Heard
Lordship.
me, heard Mr. What is not you?
Islam.
Islam, learned counsel for the petitioner, who submits that there is a bereavement in the family of the senior conducting counsel, Mr. H.R. Chaudhary, for the appellant. And on that ground, he prays for an adjournment. The prayer is allowed. Let this matter be listed
On 22,
after vacation on a date to be fixed by
and it's
registry.
in Padhad matter, your lordship.
Partnered with me.
Yes.
Fifth of November.
November.
On 5th of November after vacation. Yes, next.
I live on
34. You have any objection? On request of learned counsel for both the sides, let this matter be listed after vacation on a date to be fixed by registry.
May I please, your lordship? Item number 7, my lord.
So the next date before the next court below is 7th of October, my lord. So can it be after reopening, my lord?
No, why it cannot be today?
My lord, as per my instruction, another witness has been examined, my lord. So if it is he is examined, my lord, we'll place the certificate of your deposition, my lord. If examined, my lord.
So after reopening,
7th is the next date, so after reopening, my lord. 22nd, 23rd, my lord. Any date is lordship, please.
heard Mr. N. Mahajan, learned counsel for the petitioner, who submits that the case before the trial court is fixed for evidence of prosecution witnesses on 7th of October, and therefore prays listing of this case after the said date. The prayer is allowed. Let this matter be listed on when?
Any
30 October.
30 October.
30 October.
Obliged, my lord. Item number 20, my lord.
Yes.
Well, here, 20. Well, here, Koiki's bill application has been rejected by the coordinate bench, my lord. So it would
It will go before that.
before that bench.
Heard Mr. N. Mahajan, who submits that the application of a co-accused, bail application of co-accused has been rejected by a coordinate bench of this court. And therefore, as per the prevailing notification in this regard, this matter should be taken up by the said bench. Considering the submission made by learned counsel, registry is directed to place this matter before appropriate bench.
Obliged, my lord. Highly obliged.
May it please your lordship, lordship, with the consent of other side, I beg to mention item number 31, lordship. Lordship, the senior counsel is not feeling well, he's suffering from viral fever. So lordship, the matter may be taken after Puja vacation.
Heard Miss
J. Bezbura.
J. Bejburwa, learned counsel for the appellant.
Yes, lordship.
Appellant submits that the conducting counsel is indisposed and on that ground prays for an adjournment. She also submits that she has informed the counsel for the other side regarding, you are appearing. What is your name? Also Miss M. Kolita, who does not have any objection to the prayer made by learned counsel for the appellant. Hence, the prayer is allowed. Let this matter be listed after Puja vacation on a date to be fixed by registry.
Obliged.
May it please the lordship. Lordship, I beg to mention item number 11, my lord. Can it be taken up next week, my lord? I'm paying for an accommodation on behalf of my senior, Mr. H.R. Chaudhary.
Okay. Heard Mr. M. A. Chaudhary, learned counsel for the petitioner, who prays for an adjournment on the ground that there is some personal difficulty on the part of learned Mr. H.R. Chaudhary, learned senior counsel engaged by the petitioner. No objection. Any?
Next week, charges has been framed. Charges has been framed, my lord, on 28, 2024, as per our instruction. And report has also been received. Report was.
This is on what ground?
This is, my lord, on the ground of that recovery conscious possession, my lord, which has been argued in this case.
On merit?
Yes, my lord. One chance, my lord. Next week.
No, let us see. Let this matter be listed. When do you want?
My lord, let it be on 3rd of October.
3rd of October.
Third. I'm deeply afraid of you.
May I, lordship, I beg to mention, lordship, item number 5, lordship. The counsel for the petitioner is out of station,
What
lordship.
is your name?
S. Kathak, lordship.
Heard Mr. S. Kathar, learned. Have you informed the other side?
Yes, I have taken the consent of the other side.
S. Kathar, who submits that the conducting counsel for the petitioner is out of station, and on that ground he prays for an adjournment. He has also submitted that he has informed the counsel for the other side regarding his prayer for adjournment. Stop. The prayer is allowed. Let this matter be listed after puja vacation on a date to be fixed by registry.
May please your lordship. Lordship, matter is being listed in the motion column for the second time today. We have already taken steps.
What is the,
Petitioner is behind the bars for 9 months now.
whether,
matter.
whether notice to respondent number 2 is served?
We have taken steps, lordship, but I think
You have to find out. When will you find out?
lordship. LCR has also not been received. Lordship may also call.
Then it will go beyond puja.
Lordship, we can fix it in the next week. We can
Okay,
try once.
okay,
It is from
then.
Morigaon.
Okay. Heard Miss N. Sultana, learned counsel for the petitioner. Also heard Miss N. Das, learned additional public prosecutor. On perusal of the office note, it appears that the notices issued to respondent number 2 has not yet returned. Learned additional public prosecutor is requested to let this court know about the fate of the notice issued to respondent number 2 through the officer in charge of jurisdictional police station. It also appears that the no, scan copy has not yet been called for. It is a charge sheeted case.
Yes, lordship. Charge sheeted case.
Stop. It also appears that for consideration of the instant bail application, scan copy of POXO case number, the records of POXO case number 10/2024 would be necessary. Hence, call for the same registry to requisition the scan copy. Let this matter be listed on 4th of October 2024.
May I please your lordship? The lordship petitioner is already died, so we need to file substitution.
Petitioner has expired.
Yes, your lordship. On 22/8/2024, your lordship.
Heard Mr.
A. Hussain, your
A.
lordship.
Hussain, learned counsel for the petitioner. Also heard Mr. M.K. M. Kashyap, learned counsel for the respondent. Learned counsel for the petitioner has submitted that petitioner has expired on 24/8/2004.
22, your lordship.
22/8/2024. And in view of the same, the petitioner, in view of the same, necessary appropriate steps shall have to be taken for substitution of the legal heirs of the petitioner. And for the same, he prays for some time. The prayer is allowed. Let this matter be listed after puja vacation on a date to be fixed by registry.
Obliged to you.
May I please, lordship? Lordship, this matter relates to Patasilambari PS case number 226 of 2024 under section 6128/306 317/4 317/5 and 36 of Bharatiya Nyaya Samhita, lordship. In this case, lordship, the petitioner is not a named accused.
What are the offenses?
These are the offenses related to sale of scrap materials related. Lordship was pleased to allow the co-accused where the named in the FIR to go on bail on 11/9 and 12/9, lordship. One was Rakesh Goala and the other was Ratul Kakoti.
Who is Rameshwar Chaudhary?
Rameshwar Chaudhary is the person who is on rent in the house of in the premises of Rameshwar Goala, who was the prime accused, lordship, who was arrested. He is a mere tenant, lordship, and that he was running his a business of motor spare parts, lordship, in Lokora.
Case diary would be required.
He is not a name accused, lordship, and the other persons were allowed to go on bail, lordship.
After perusing case diary, they were allowed to go on bail.
I'm not a name because my name was even not in the,
Then why are you apprehending your arrest?
because the police was visiting my business place, Lordship.
Because
Since
this,
since for the 24/8/24, Lordship,
Okay,
I was not in the
we'll fix a short date. We'll fix a short date.
Lordship.
Heard Miss B. Sharma, learned counsel for the petitioner, also heard Miss N. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner Rameshwar Chaudhary, who is apprehending his arrest in connection with Patasil Ambari PS case number 226/2024. Considering the nature of offense involved in this case, perusal of the case diary would be necessary. Hence, call for the case diary. When can you call? Let this matter be listed again on 4th of October 2020.
Master place.
Hearing is item 8.
May I please your lordship? The charge sheeted matter, lordship, I put a order to the date. Lordship will come to page 32, lordship. There is an order from this honorable court, lordship. Lordship will kindly come to page 32, lordship. It's a commercial quantity charge sheeted matter, lordship. Page 32 is the order, lordship, earlier rejected, lordship, by this honorable court, and thereafter, lordship will turn to page 34, lordship. 34, the operative portion, lordship. Page 34, lordship.
Yes.
Page 34, lordship, it is, at that time petition was rejected, lordship. It says that it is, however, provided that learned trial court should make an endeavor to complete the examination of PW within a period of 5 months from the date of receipt of a copy of this order, failing which the court shall consider bail application favorably subject to stringent condition, lordship. There was a lordship, order to consider the bail application favorably subject to condition, lordship. That order was passed on 14/9, lordship. 14/9/2023. It was passed, lordship, and thereafter, after the period, lordship, stipulated period, lordship, a bail petition was filed before the honorable trial court, lordship. That was rejected. And now I am here, lordship. and it is
Rejected on
pending.
what grounds?
Lordship, that
Where is
clearly
that?
says order, lordship.
Where is that rejection
That
order?
was not completed, lordship.
Where is that rejection order?
That rejection order, lordship, will find on page 36. The earlier High Court order clearly says, lordship, if it is not completed within 5 months, it should be released on bail, lordship. That page 36. lordship, will-
Rejected on the ground that 37 embargo is there.
that is the ground, lordship. Thereafter, I have come before this honorable court, lordship, and since then it has been pending, lordship. I have approached here on month of March, lordship, and now, lordship, will see that 2 years already been gone, lordship.
When were you arrested?
Arrested on, lordship, will kindly turn to page 2, lordship, 38, lordship. Already 2 years has gone.
How
lordship.
many days you are?
Exact date is, lordship. Days to good lecture. 775 days, lordship.
In years?
Years, 2 years, 1 month, 25 days.
When the charge sheet was laid,
Charge sheet was laid on 30/11/2022, lordship.
when the charges were framed? 2012, 22. How many witnesses are listed?
No, not closed, lordship. There is a,
Witnesses,
again, lordship, for re-examination, cross-examination, lordship, was called, lordship. This is
witnesses
the order,
closed.
lordship, will kindly. That was long back, lordship, in the month of, I think, April. Lordship will see the latest lordship. This is the latest, lordship. It is the order of 19/9/2024, lordship, which says the accused produced before me no PWs are present. Issue summon to OC Delay PS for his cross examination, and he is asked to be present with general diary, volume, Malkhana register, and so, effect from so, remain the accused till 3/10, 2024 for production and cross examination of CW1. And two more lordship is there, lordship, if I'm not wrong.
Where is the status report?
Lordship, I think lordship, I have checked it, lordship, it is of April. Lord.
Then we have to call for again.
Lordship, kindly, lordship, there are more than 2 years, lordship,
No,
and there
but
is a
the-
standing order from this honorable court also, lordship.
But the trial is over.
More, lordship, they clearly says, lordship, no PWs are present. Clearly says, lordship. It is a,
No, you find out today. This order is of, when?
this is of 19/9, lordship, and next day it speaks on 3/10, lordship. Since long, lordship, that PWs are not
What is the
appearing. lordship.
contraband? How much?
So 380 grams, lordship, of heroin, lordship, and metformin, lordship, 2.28 kg, lordship.
Then we will call for we'll call for the status report. Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. It appears that the status report of the trial available before this court is of 14/5/2024. Though learned counsel for the petitioner has submitted that the case is the NDPS case number 94/2022 is fixed before the trial court on 3/10/2024 for cross-examination of court witness number 1. However, learned additional public prosecutor has submitted that the prosecution witness has already been closed. In view of the submissions made by learned counsel for both the sides, you have the evidence of the testimony is there. They have implicated. In view of the submissions made by learned counsel for both the sides, latest up-to-date status report of the special NDPS case number 94/2022 be called for from the Court of Learned Special Judge Karbi Anglong to reach this court. When is the next date?
3/10, lordship.
3/10. On
14, lord. 14, lordship. Already 2 years has gone, lordship, and there is a standing order from this honorable court.
on
also there.
22/10/2000 after vacation, on 22/10/2000, the trial court is directed to expeditiously dispose of the trial. Let a copy of this order be also furnished to the trial court. Registry to take steps for requisitioning the updated status report from the trial court as on 22/10/2024.
One small correction is there. I may be permitted through the correction. lordship.
Which correction?
In name, lordship, one small correction is there.
What correction?
The Lordship will see the first page, Lordship. Their Lordship, another name has been their Lordship. In the cost title, Lordship. That may be corrected. One correction, Lord.
What?
First page of the cost title.
Yes.
There wrongly it has been typed out of it.
Which is the correction which you want to say?
That Mohammed Asraful Losco Lordship, that I will correct it. His name is Rajesh Lakhandi. Lordship in cost title.
This is not a small correction.
No, but in the name Lordship, it isn't correctly put. In the second page, Lordship,
You
is correct.
file an application.
No, Lordship.
No, then you will have to face consequence of this error. This is a NDPS case involving commercial quantity of contraband. So, and names are not named.
No, Lordship, it is not necessary to put the name there, Lordship. In that first cost title, it is not necessary to put the name, Lordship.
There is a notification how you should make corrections of this registry.
No, here, Lordship, it is not necessary to put the name of the accused.
Then
Lordship.
don't correct it if it is not necessary.
If Lordship permit, Lordship, I will
No,
correct it.
I am permitting it, but following the due procedure as laid down by the notifications. You may correct it, but following the notification in that regard, how to correct the cause title, not by hand. Because this is not spelling mistake. This is a different accused.
Oh, Lordship.
List accordingly.
Much obliged, Your Lordship. Much obliged.
The report of fact. Item 90 as a. You are. Why adjournment of whose personal difficulty that you're conducting councils. Okay.
My lord may kindly my lord may kindly have a look on the LCR, Lordship, whether it is up to date or not, Lordship. If not, Lordship may then call for the up to date scan copies also. As because, Lordship, so far my instruction goes, Lordship, the last date was fixed on, Lordship,
Okay.
13th of September,
Heard, Mr. What is
29th
your,
September, Lordship.
what is your name?
M. Ahmed.
M. Ahmed, learned counsel for the petitioner. Also heard Miss, what is your name? N. Kakoti, learned counsel for the NCB, who prays for an adjournment on the ground of personal difficulty of standing counsel for the NCB name Mr. S.C. Kayal. The prayer is allowed. It appears that the status report available before this court of the NDPS case number 9/2022 is of 6/5/2024. Let an updated status report be called for from the trial court registry to requisition the updated status report of the NDPS case number 9/2022. Let this case be listed again on 24th of October 2024.
Highly. My lord may kindly fix it either 23 or 25th, Lordship.
25th of October, remember.
Highly obliged.
Item.
My pleasure. This is a POSCO case, my lord, and it's on 6, my lord. And
Respondent number 2,
respondent number 2, we have already taken steps by, as per the only which one appointment of the amicus curiae.
this is a charge sheeted case.
It's actually evidence already recorded, my lord.
Then we'll appoint an amicus.
The amicus has to be appointed.
It's a case of actually what happened, my lord, I just, though there is allegation of causing sexual assault, my lord, aggravated sexual assault. But the fact remains that medical evidence is totally nil.
Okay, let us
To those-
appoint,
In those cases where variation of between the medical evidence and ocular version, my lord. Otherwise, as your lordship knows, eyewitness has to give a primacy in cases like this, but when the ocular evidence totally negates.
heard
medical-
Mr. P. Kotoki, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public
Yeah,
prosecutor.
yeah, what again?
This,
Okay, therefore,
It-
mind again. Mind.
where is the report of service on respondent number 2? Learned learned additional public prosecutor has submitted that the notice issued to respondent number 2 has been served by the officer in charge of the jurisdictional police station. And in that regard, he has furnished a copy of report received from the in charge of Bidyapur police outpost. This can be kept in the case record. Let the said notice be kept in the case record. As no one has appeared for respondent number 2, this court is inclined to appoint an amicus to defend the cause of the amicus list. Any amicus present in the court?
तुम्ही असं नाही करत. त्यामुळे एक घेतली जाऊन घ्या तुमच्या. मला
Amicus, stop. This court appoints Srimati Meghali Burman as, no, not Meghali Burman.
follow up to that করা আমাদের পড়ি আছে ও চিন্তা করি না
Surajit Das as an amicus to defend the cause of respondent number 2. The registry shall furnish a copy of necessary papers to the learned amicus and list this case for hearing, bail hearing on when do we fix it?
Yeah, the copy has to sub to the amicus also, my lord.
Yes, that I have
So your lordship may fix any date, my lord, subject to your lordship's
after
convenience.
Puja vacation
Necessarily.
on 25th of October 2024.
Maybe, bill may relates to one of POXO case. Case has been registered under 8 and 10, madam. It's a state case, madam. Madam, scan
Whether-
copy was called for.
With the notice to respondent number 2 has been,
Taken steps, madam.
you have to take instructions. When will you inform? Heard Mr. A.K. Sharma, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. It appears that the report of service of notice on respondent number 2 has not yet been received. Stop. Learned additional public prosecutor is requested to take instructions, necessary instructions from the concerned officer in charge of police trails. From the officer in charge of the concerned police station regarding service of notice on respondent number 2, and let this court know about the fate of the notices. The scanned copy of the trial court record has already been received. Let this matter when? No,
3rd October. No, so it's
Before
possible.
vacation, you have to inform before vacation. Let this matter be listed again on 3rd of October, 2024.
Problem.
May I plead your lordship? Search case, your lordship, NDPS commercial quantity. Your lordship, FIR is on page 11.
When were you arrested? What
I'm
is your
arrested.
ground?
10/5/2024.
10/5/2024.
Yes, your lordship.
What is the contraband? How much?
1 kg, 788 grams.
What is your ground? It is pending investigation. Charge sheet has been
Search
sub.
sheet, your lordship. Your lordship, kindly see the FIR, your lordship, page 11. Nothing has been recovered from my possession, your lordship, and I am arrested and subsequently searched only on the statement of the accused, your lordship. That too, and the accused were under the police custody, and which is not admissible as per the Apex Court judgment in Tufan Singh, your lordship.
No other material.
Nothing has been recovered from my possession, your lordship.
From where you were arrested? What is the allegation against you? Wow.
And I was a registered owner of the vehicle as a Swift, Maruti Swift, your lordship.
And what the co-accused have stated about you? Mr. Sharma, go through the record. Is there anything else apart from the statement of co-accused? There is evidence that he was in the vehicle.
Your lordship.
Owner of the vehicle.
Owner of the vehicle, your lordship. Nothing has been recovered from his possession, your lordship.
But vehicle is yours.
Your lordship.
And report regarding owner's details of vehicle. That is there. The vehicle-
Mhm. Then- The car was hired from me, your lordship.
How they have, what is the implicating statement?
Lordship.
How they have implicated, what they have stated, what co-accused have stated.
Statement I don't have, your lordship. Yet as per the forwarding report, it is stated that as per the statement of the co-accused, on that basis, I am arrested.
No, you are arrested. After arrest, what evidence was collected? Mr. Sharma, go through the how he is connected with the offense. Apart from being registered, if the vehicle was hired, if the vehicle was, whether the vehicle was used without his knowledge. If that is the case, he may get bail. If otherwise, other evidence is there, then bail may not be granted. You go through. When? We'll take it up at 2. Let him go through the scan copy.
Oblige, your lordship.
Not 14 maybe password for time being, well, can it be taken after some time?
Okay.
Lordship, and this item kindly be taken, not today, your lordship, some difficulties.
Okay. You will get more time. Heard Miss
F. Hussain, your lordship.
F. Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some time to go through the scan copy of the case record received from the trial court before he makes his submissions in this case. The prayer is allowed. When?
After vacation,
Let this matter be listed after vacation. Let this matter be listed again on 24th of October 2020.
oblige your lordship.
May it please your lordship. This is a regular bail application. The petitioner was arrested on 7/9/2021, your lordship. Today it is 3 years, 1 month. Your lordship, the charge sheet was, this is a commercial quantity of your lordship.
Whether
putting syrup.
the records were called for. It is there.
It is there, it is there.
Oh. The bail was rejected by a coordinate
No,
bench
no, this bail was not easy.
of the same police station, same. Then it has to go to, there is a notification. If a court deals with a particular case, right? Heard Mr. Y.S. Mannan, learned counsel for the petitioner. Also heard Ms. M. Deka, learned counsel for NCB, who submits that a bail application of the co-accused in this case was dealt with, was considered and rejected by a coordinate bench of this court within bracket, Honorable Mr. Justice R. Fukon, bracket close. And hence, as per the notification number 32 dated 30/5/2024 issued by the registry of this court, this matter shall have to be taken by the same bench.
Here is it.
Stop. The registry is directed to list this matter before the appropriate bench. Before the
Lordship may have it then put it after the vacation.
appropriate bench after the vacation.
Much so fast.
Right, my lord, these two accused persons were arrested about more than 1 year, 3 months ago in connection with this case, and the case is already pending trial in the court of learned.
Date of arrest?
Date of arrest, lordship will find at 25 June 23. And since after 9 months, charges were framed in this case, and thereafter waiting some point of time, trial commenced. And
What is your ground?
ground is that they were not in conscious possession of the illicit contraband which was recovered from a truck. And second thing is that there are, my lord, lordship will peruse the paragraph 4 of this petition, my lord. I have clearly narrated the record of proceedings. At last line sentence, my lord. It is pertinent to mention here that the aforesaid case, i.e. NDPS case number so and so was fixed on 3rd June 24, 15 June 24, 29 June 24.
No, that prolonged incarceration.
Both are in custody.
No, you,
Not driver, owner and driver. Petitioner number is the one is the owner and the two is driver of the said vehicle. So last, my lord, paramount consideration before your lordship is that on last 6 dates, the PW3 is absent. So already out of 9, 2 have been examined, my lord. And considering the length of detention, my lord, there should be released on bail subject to any terms and conditions as earlier.
no, but length is not so long.
So,
Do you,
but they have not conscious possession, my lord. There may be some conspiracy, it may be proved beyond reasonable doubt during the course of trial, subject to any terms and conditions. And considering the length of detention of 1 year, half months, there are so many Supreme Court.
but you have not completed 1.5 years.
That is true, my lord.
So on that ground, it is to be rejected only.
No, no.
You have not completed.
That cannot be, my lord. That cannot be, but every case stands on some different standards, my lord. So your lordship has also pronounced a similar nature of orders earlier.
No,
Like
that
this case, my lord.
in no case it is less than 1 year, 6 months.
in Robi Prakash, my lord, and some other cases also Supreme Court.
You show me any case where in 1
Then
year,
I
3
have to
months.
go through this. The lordship will go through this order of your lord.
No, what was the period?
Period, lordship was detailed analyzed in this case, so lordship may kindly peruse before passing the order. Because maximum paramount consideration is the progress of trial in this
No,
case. They are
not
out
the
of,
progress of trial, but the length of your
yes, length of
incarceration.
detention is also
In
significant
this
factor.
case, the petitioner was behind the bar
1 year.
for for 2 years, 9 months.
No, that was not the case. There are some reference of Honorable Apex Court orders inside this order passed by your lordship in various paragraphs, preceding paragraphs.
No, but in this case, you go through the case properly.
Yes.
It is 2 years, 9 months.
No, I am not about with this case particularly. There are some Supreme Court references are already.
In all cases,
considered-
in none of the
considered.
case, it is less than 1 year, 6 months.
Yes.
And you have not completed that period.
That cannot be termed to be as a mandatory period as per dictated by the.
No, you
Honorable
show
Apex
me what should be
But
the,
the 1 year, 3 months is not a so much, very few length of detention, my lord. That is also because their families are, they are surviving with this business
what
of.
is your submission?
That cannot be, that was the standard set by the Honorable Apex Court on the basis of the facts and circumstances of the case. But here in this case, my lord, that 1 year, 3 months is not a so little period for detention. That can be considered also, my lord.
Heard
Considering-
Mr. A. Paul, learned counsel for the petitioner, also heard Ms. N. Das, learned additional public prosecutor. This application under section 483 of the BNSS has been filed by the petitioners, namely number 1 Sukhdev and number 2 Happy Singh, who are detained behind the bars since 25/6/2023 within bracket for last 1 year, 3 months in connection with NDPS case number 42/2023 corresponding to Rangya PS case number 361/2023 pending before the court of London. Which court it is pending?
Special Judge Kamrup.
Special Judge Kamrup.
Rangia.
Court of Special Judge Kamrup Kumar Rangya. The gist of accusation in this case is that on 25/6/2023, an FIR was lodged before the Rangya police station, wherein it was alleged that the where is the FIR?
FIR lordship will find at page 11 to 16, operative portion at page 15, my lord. 15 is the written.
How much was the contraband?
Contraband was recovered, which contraband was recovered? It was a case of morphine, my lord.
Wherein 5.16 kgs.
But the seizure list speaks some different. It was some quantity recovered in different 5 packets.
Where is this seizure list?
Seizure lordship will find at page 22. Collectively, if the quantity of seizure be considered, all the small quantity in separate. That is in total 5.016 kg of narcotics, plastic pouches from the possession.
What was seized?
This is only this. And along with two
what
mobile
was the
num-
material?
along with two mobile phones and cash of 15,000 and the truck itself. At
Opium,
OPM. Yes.
5.016 kg of opium was recovered from the truck bearing registration number PB65BC 5967 stop. And the above named petitioners were arrested were found in the said truck and were also arrested. After receipt of the said FIR, Rangya PS case number
361.
361/2023 was registered, NDPS was registered and investigation was initiated. On completion of the investigation, charge sheet was laid against both the above named accused persons under section 16
Section 17C, stroke 21 of the NDPS Act.
C
And 29.
/29 of the NDPS Act 1985. Learned counsel for the petitioner has submitted that the petitioners are innocent and the contraband was not seized from their conscious possession. Learned counsel for the petitioner has also submitted that the petitioners are languishing behind the bars since last 1 year, 3 months. And considering the prolonged incarceration of the petitioners, they may be allowed to go on bail. He has referred to a judgment passed by this court in the case of Javed Iqbal versus Union of India, within bracket order dated 17/5/2024 in bail application number 538/2024, wherein several rulings of the apex court has been considered and bail was granted to the petitioner of that case on the ground of prolonged incarceration. Stop. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioner on the ground that there are sufficient incriminating materials against the petitioner on record. And as commercial quantity of opium is involved in this case, the embargo of section 37 of the NDPS Act would be applicable. She also submits that the period of 1 year, 3 months may not be considered as long incarceration so as to entitle the petitioner bail on that ground only. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the scanned copy of the special NDPS case number 42/2023. So it appears from record that the petitioner Who are the petitioners? Name?
Sukhdev and Happy Singh. Sukhdev is the owner of the truck.
The petitioners were apprehended from the truck from which the contraband was recovered. It is also revealed in the investigation that the petitioner number 1, Sukhdev, is the owner of the truck, whereas the petitioner number 2, Happy Singh, was the driver of the truck. The materials available on record shows that there are incriminating materials available on record, which available on record against both the petitioners. And as such, this court may not arrive at a prima facie opinion that there are reasonable grounds for believing that they are not guilty of the offense against which they have been charged with. Next para. As regards that prolonged incarceration is concerned, though the apex court has observed in several of its rulings that prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution of India. And in such a situation, the conditional liberty must override the statutory embargo created under Section 37 of the NDPS Act. However, to give the benefit of prolonged incarceration, the court has to come to a finding that the incarceration of the petitioner is long enough so that it can be held that under some such circumstances, the fundamental right guaranteed under Article 21 of the Constitution of India has outweighed the fetters imposed by Section 37. In this case, the petitioner has been behind the bars for only 1 year, 3 months. And in none of the rulings cited by the learned counsel for the petitioner, the benefit of bail was granted to any of the accused person on the ground of prolonged incarceration, where for such period of incarceration. In the minimum period for which the apex court has granted bail to the accused charged with possessing commercial quantity of contraband appears to be 1 year, 6 months. This court is therefore of considered opinion that the incarceration undergone by the present petitioner in the instant case is not long enough so as to give him the benefit of bail, ignoring the embargo of Section 37 of the NDPS Act. view of above, the application for bail of the present petitioner is rejected at this stage.
Trial of the case may kindly be directed to expedite so far as possible. Lordship may direct it, or it may be or may not be.
The trial court is directed to take all steps to expedite the trial of special NDPS case number 42/2023.
May it please your lordship. Well, for 83 bail application, my lord, the lordship will find the affair as is at page 9, my lord. My lord. Page 9, my lord, is that.
Whether the respondent number 2 has appeared,
No, my lord.
you have issued notice.
The notice was issued, my lord, steps were taken, my lord. My lord,
This was dated 29/22.
20?
September.
No, notice has to be sent not through post, but through the PP as per the prevailing notifications, not by registered post. You take fresh steps as per, there is a notification number 17. Notification.
my lord, through PPO was also taken.
Through PP, when have you taken steps?
10/9, 11/9, my lord.
But yes, 11/9. You have to find out, Mr. Sharma. You find out whether notices are heard. Mr. What is your name?
Mr. S. Hoffman.
Heard Mr. S. Hawk, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. It appears from the office note dated 13/9/2024 that the petitioner has taken steps for issuance of notice to the respondent number 2 through jurisdictional police station, through the officer in charge of jurisdictional police station. However, the service report is service report has not yet been received from the concerned, from the officer in charge of concerned police station. Learned additional public prosecutor is requested to take necessary instructions from the concerned police station and let this court know regarding the fate of the notice issued to respondent number 2 on the next date. When?
My lord, 3 of 3rd of October.
Let this case be listed again on 3rd of October 2000.
I am obliged.
May I please, your lordship.
Lord, scan copy as called for, that is before your lordship. And with regard to my lord, respondent number 2, service is complete. Then my learned friend is appearing on behalf of my lord, respondent number 2.
Okay, okay.
Lordship, kindly have a look, my lord.
You have anything to say? You are objecting the bail.
My lord, 164 statement is there. My lord,
Now, at what stage the trial is pending?
Evidence is this, my lord.
Whether the victim has been examined.
Not yet examined, my lord.
Charges has been framed on 18/9/24.
Now, my lord, regarding my lord, her age and my lord section.
Where is the
Lordship.
164 statement?
There is one record.
What she has stated?
She has stated that my lord, love affairs was there. Out of love affairs, they were fled away. And my lord, victim recovered from the my lord, house of the my lord, accused before your lordship. My lord, charges are framed. Law will take its own course. We are not on that. Lordship, just we are praying for bail, my lord. As on
No,
today,
you can influence the victim.
my
In
lord.
POXO cases, at least victim has to be examined.
Well, her statement is there, my lord. 162 statement is there.
First statement was the implicated person. She had stated that she was induced by means of marriage and he committed forceful intercourse.
Where is that state? You flag it. Dioksun. If she has implicated, then you have to wait till her
Examination.
examination.
Lordship.
I'll dispose it off with that observation that
Right.
if there is an implication. You are father of the victim,
Mother. His mother.
mother of the victim. Heard Mr. K. Rahman,
Rahman, yes.
learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. You got it?
Yes.
Also heard Mr. What? N. Hussain appearing, N. Uddin appearing for respondent number 2. This application under section 483 of BNSS, 2023 has been filed by the petitioner petitioner Mohammed Ismail Haq, who has been detained behind the bars since when?
15/6, my lord.
15/6 to 2024. In connection with special within bracket P case number 77/2024 arising out of Shampur Police Station, case number 9/2024 under section 366/376 of the Indian Penal Code, read with section 6 of the POXO Act, 2012. The gist of accusation in this case is that on 14/6/2024, the mother of the victim girl lodged an FIR before the officer in charge of Shampur Police Station, inter alia, alleging that about 1 month prior to filing of the FIR, her minor daughter was found missing from her house. And on 12/6/2024, she was recovered from the house of the accused named in the FIR within bracket present petitioner. It is also alleged in the FIR that the victim was kidnapped by the petitioner and was kept in his house and she was subjected to forceful sexual intercourse against the will of the daughter of the first informant. Stop. What is your submission?
Lordship, law will take its own course, just my lord, considering the length of detention and my lord, out of love affairs that is happening.
Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars since
15-6.
15/6/2024. And considering the period of detention, he may be allowed to go on bail. He has also submitted that there was a love affair between the petitioner and the victim girl.
Yes.
Stop. And hence, he has prayed for allowing he has also submitted that the petitioner would cooperate in his trial and therefore he may be allowed to go on bail. Learned counsel for the informant who is the mother of the victim, you are not opposing, has also not opposed the grant of bail to the petitioner on the ground that the mother came to know that there was a love affair between the petitioner and her daughter. Stop. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioner on the ground that the victim girl was aged about 16 years only at the time when the alleged offense was committed. He also submits that in her statement recorded under section 164 of Code of Criminal Procedure, 1973, the victim has stated that she was forcefully subjected to physical intercourse by the present petitioner on pretext of marrying her later on. What is this Bannat? You have read the you read the underlined word. What is the meaning of this? Charges have been framed.
Yes, my lord.
Yes. When? What is the meaning of?
Banat Madrasa, girls Madrasa, my lord. Banat.
Okay.
Banat is from Arabic term.
Okay. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record, including the scanned copy of the record of the trial court. It appears that the charges under section 366/376 within bracket 3 read with section 6 of the POCSO Act have been framed against the present petitioner on 18/9/2024. And the next date is fixed
310.
on 3/10 for evidence of the prosecution witnesses. Stop. 344. Charges. 376/344 and query. Though the counsel for the petitioner has counsel for the respondent number 2 as well as learned counsel for the petitioner has submitted that there was a love affair between the victim and the love affairs between the victim and the petitioner. However, considering the fact, considering the statement of the victim recorded under section 164 of the Code of Criminal Procedure, as well as considering the fact that the next date in the trial, next date before the trial court is fixed for a recording of evidence of prosecution witnesses, this court is not inclined to grant bail at this stage. Stop.
My lord, sorry. One date maybe, my lord, fix for you. Yes.
I'm rejecting this petition. You may approach before the trial court after perusal of after recording of the evidence of the prayer for bail is therefore rejected. However, it is observed that the petitioner may approach the trial court after recording of the evidence of the victim girl by the trial court and may pray for bail at that stage. And on such an application being made, the court shall consider the same as per law. This bail application is accordingly disposed of.
Obliged.
If Lordship have earlier rejected it, Lordship, now we are on 86 days, Lordship. 90 days is a mandatory period, Lordship. There is the case of allegation against rape, Lordship.
Rape?
Lordship, but is a consenting party, Lordship, only heard that he had cheated, Lordship, as he belongs to Hindu community, Lordship. That is the main allegation, Lordship. The page 10 is the FI, Lordship.
What is your submission, Mr. Sharma?
Earlier rejected, Lordship. Now we are on 86 days, Lordship. If charges has not been laid down, Lordship, that 4 days benefit, Lordship. That is the.
No. Why to give you 4 days benefit? There must.
Because it is a consenting party, Lordship. Only sitting party is there, Lordship. Clearly revealed from the FI, Lordship.
Where is the rejection order? You can only fix it after 4 days. If charge sheet is not filed, you will get bail.
Case there is here, Lordship.
After 3 days, only in that, considering the nature of offense. Because this plea was.
Plea was only cheating,
Was
Lordship.
considered earlier by this court
Lordship,
and was
Lordship,
rejected.
Only the thing is that, Lordship, her grievances is not regarding to rape, Lordship, only for the cheating part, Lordship, that he says to
No,
belong to
but
a
that
different.
was considered by this court earlier.
That I understand, Lordship. That
We
was-
can do two things, either to dismiss this now or to fix it after 3 days.
Lordship, 3 days, Lordship.
Heard Mr. S.
Monday,
Muni,
Lordship.
S. Muni, learned counsel for the petitioner, Also, Mr. B. Sharma, learned additional public prosecutor. Let this case be listed again. 86.
30 Lordship.
First of October.
Then 91 days Lordship.
On 30 September 2020.
Much obliged. Much obliged.
May it please your lordship. Here, FIR your lordship will find page 8 and contents at page 10.
Just a minute.
Page 10. May I read?
No, just a minute. 22C.
Lordship.
Case there is there.
Certificate
sheeted-
records received.
Yes, page 10.
Page 10. With reference to the subject cited above, I have the honor to inform you that on 15/1/2023 at 2:30 PM, an information was received from reliable source by OC Patharkandi PS that two persons are going to deal some illegal narcotic contraband in front of Kanai Bazar, ME school at Gerermukh, Asimganj area. Accordingly, a GD entry was made by OC Patharkandi PS by Patharkandi PS GD entry number 362 dated 15/1/2024. And superior officers are informed over call, and OC Patharkandi PS Inspector Deepak Das authorized me for conducting search, seizure and arrest. If any illegal narcotic contraband found by GD entry number so-and-so, then I, along with my below named police staff of Patharkandi PS, along with weight machine and other items of seizure list for Gerukhamukh, Asimganj so-and-so. So staff, I, along with the aforesaid police party, arrived at Gerukhamukh by our gov vehicle, Bolero bearing registration number so-and-so. As per source information, after reaching at Gerukhamukh, Asimganj, we found two suspected persons standing in front of Kanai Bazar ME school. Now this line, Lordship may kindly see, one of them was holding a black color polythene. So informant knows that who was holding that bag, but instead of, he did not disclose that who was holding. He suppressed that fact and implicated both the persons. And then your lordship will find that section 29 was registered, but as per my instructions, there is no material to show that there was any abatement or conspiracy. And therefore, lordship, he knowingly withheld in whose hand that contraband was there. And if your lordship see the section 57 of NDPS Act, it says that complete report has to be informed to the superior officer. Section 57 of NDPS Act.
Yes.
May I read, section 57?
Yes. Yes.
Report of arrest and seizure. Whenever any person makes any arrest or seizure under this act, he shall within 48 hours next after such arrest or seizure make a full report of the particulars of such arrest or seizure to his immediate superior officer. Full particulars, but that particular is suppressed by the informant, lordship. In the affair, he was categorical that one of them was holding a black color polythene, but who was that person? That is not disclosed. And just I am relying on one citation, lordship.
Now, who are the petitioner in this case?
Here, lordship, that Wazuddin, one, accused number 1.
And your case is you are not holding that.
I was not holding. They have to disclose that fact.
But
If search and seizure is not in as per law, lordship, that the foundational fact of the case is not there.
No, no. Out of two, one was holding.
One was holding, but regarding other, they have to implicate as to how he is involved. If that is not there, the benefit of doubt will go to the other accused. And they were not placing the actual genesis of the case. That is my entire case. If my learned friend can place from the record that yes, it was disclosed that who was holding that, I have nothing to say about it. And apart from that, there is no material that except they were present there together. They had the knowledge or they have abetted or conspired together to those things. And in the forwarding report, it is said that confession, that is your lordship knows that Tufan Singh's judgment will come. Except that confessional, there had to be some other material. Lordship, may I kindly see the judgment which I have given to your lordship, paragraph 23.
Where is the presumption part? Whether presumption part will help?
Presumption part will come only if there proof that
Foundational.
possession. Then presumption will come.
One
But
of them
here
was
the-
possessing.
That one of them. Now against me or against the other accused.
The other one we may get benefit if there is no link.
Yes, both will get because they have to prove the case beyond reasonable doubt. This is the Draconian Act, so they have to prove with restrictions. Now, paragraph 23 of the judgment, Lordship, may I kindly say 23, 27 and 28. In paragraph 23, Honorable Apex Court judgment is relied wherein this says that if search and seizure is doubtful, that cannot be taken as admissible evidence.
Which para?
Paragraph 23.
No, but you will get this benefit only in trial.
So if the search and seizure is not proper, on that ground, Lordship, this bail was granted. The judgment which I have placed before Lordship.
23.
23.
What it says.
Khet Singh, that citation is at paragraph 27, Lordship. Khet Singh's citation 2002, 4 SCC 380.
Yes.
Law on the point is very clear that even if there is any sort of procedural illegality in conducting the search and seizure, the evidence collected thereby will not become inadmissible and the court would consider all the circumstances and find out whether any serious prejudice had been caused to the accused. If the search and seizure was in complete defiance of the law and procedure, and there was any possibility of the evidence collected likely to have been tampered with or tempered during the course of such search or seizure, then it could be said that the evidence is not liable to be admissible in evidence.
But this
So
is not
here-
applicable to your case.
No, here, Lordship, what I am trying to place for your Lordship is that the informant knew in whose hand those articles were there. He did not disclose. So this amounts to tampering with the evidences, Lordship.
No, no. How?
Because he knew, otherwise, Lordship, if Lordship, he says that it is in the hands of other accused persons, I would have get the benefit of those things, Lordship. That whether then conspiracy was there or
No,
not.
your
But he
case is-
knowingly-
your-
He knowingly said, Lordship, that these are subsequently said that these are recovers from both of them.
Your case is had he disclosed
Lordship,
in whose possession
Lordship,
he found the black polythene.
yes. Then
Then if he fails to show any link between the other accused,
Yes,
then the
exactly.
other accused will get benefit
Lordship,
from whose possession it was not
Lordship.
found.
Lordship, that is my case.
But this citation may not help you.
That I leave
This
up to your
citation
Lordship.
is
But only thing is that here in Khet Singh, it is said that if it is tampered with or
This
in
is
the-
not a case of tempering. It
But,
may be,
it is not case of tempering, but it is not disclosing the entire facts, which otherwise prejudice me. Because in the first part of the judgment which is there, the evidence collected thereby will not become inadmissible and the court will consider all circumstances and find out whether any serious prejudice had been caused to the accused.
yes, this has to be found out during the trial only by prosecution side deducing evidence.
But relying on that judgment, also this order, Kerala High Court had passed the impugned order and granted him bail. This order was passed in
Yes,
bail
Mr.
application.
Shah. Anything else?
That is my entire case.
Anything, Mr. Sharma?
That is the advance dependent on many ifs and buts. Also because he is pointing out the FIR, taking that he should disclose the fact from which whom it was recovered loss. Let him show some judgment loss. On that point, there are two persons present. And also, will kindly come to page 24 for a moment. This is the charge sheet lordship. The FIR lordship, it may not disclose from whom it was seen.
In the evidence, the person may disclose.
Also, will kindly come to page 24 for a moment.
Page?
24, charge sheet. Just now, he also pointed out, lordship, that it should have mentioned that it has been recovered from the two persons.
No, just a minute. I'm taking a short break. Yes, Mr. Sharma. Page 24.
Charge sheet, lordship.
Yes.
Find down below brief of the case and highlighted.
Yes.
After looking. I will skip the first paragraph of it. Accordingly, a DD entry was made by so-and-so, by so-and-so. And yes, Vital Secretary was authorized to conduct search in an arrest according to the along with search. It is removed and found two suspected persons containing suspected Yaba tablet. This is so-and-so. 7 number of tablets in possession of two victims' names. Just now he stated also that they should have mentioned it as two persons. Now it is mentioned as two persons in the charge sheet also. It's not necessary to disclose everything in the FIR. Secondly, case is fixed on trial is not yet started also. Is fixed for copies on 17/9/24. All these arguments can be taken care of at this stage of.
This Yaba tablet contain methamphetamine.
The case is fixed on 17/9/24. Charges has not yet been framed. All these arguments lordship can be advanced at the stage of pending of charge, which is whether 29 will be effective or not.
No, that can be decided at the bail application also, because here also a question of liberty is there. And if I am not wrong, lordship, in page 24, it is said that tablets from the possession of two accused persons. But FIR is categorically said that the contraband was in the hand of one person. So they may say anything in the charge sheet, but that has to be examined by your lordship by comparing those statements. Lordship. In the FIR, it is categorical that one person was holding that. Now they are saying possession. Now possession can be mental through that also. And whether that material they have found to state in the charge sheet or not, that has to be seen. Because they are saying that possession rightly, but whether that animus is there or not, those things they have to be mentioned, lordship. They have to find any material to that effect, lordship. They have filed charge sheet.
Whether FIR should contain only animals regarding possession, everything should be mentioned in the FIR.
No, I am not on that.
No. FIR should not, FIR may not mention anything in detail, but his submission is that when investigation was completed, when charge sheet is laid under 29,
yes,
that there is some conspiracy or abatement, then what is the material for, because
The FIR does not disclose.
No,
that
no,
it
no,
was
no, no,
recovered
that is
from-
not my case. I have said, I have said that in the FIR, it is categorically said one of the person has, was holding that article. And who is that person? If there is anything to in the record, I have no case. I have started with that, started my argument with that logic. He can submit from the record also, records are here. If he can produce one single thing that, yes, he was also involved, this is the material. I have no case. I have nothing to say. Lord.
suppose two persons are there,
Yes.
A and B. A is possessing contraband and B is not known to A. Both of them do not know each other, but they were seen together by the police officer, and police officer saw A possessing contraband, but he implicated both of them. And then for filing charge sheet for implicating B, he has to show some material that what are the materials against him, because he saw the A possessing contraband. In this case, his submission is in the FIR, he disclosed that the contraband was in the hands of one of the accused. Then there has to be some material implicating the other accused. That is his defense.
In the first part of the FIR, also it is basically stated that as per information, 2 persons were there. That part is also there.
No, two persons, there is an information.
Yes. That 2 persons are going to deal some.
Yes, two persons were there. But who is that second person? To implicate the second person, some material has to be collected during investigation, except the confessional statement. You have to, at this stage, if suppose no material is against, his submission is that who is that person who was holding the contraband is not identified. Therefore, and he's claiming that I was not holding that. So you have to go through the materials. Let him go through.
As part heard.
No,
Lordship has
not.
heard this matter already. Because
No.
only he is seeking only time to verify that. He will address the issue, Lordship. Otherwise, again, I have to start from beginning. Only he will address if any material is found, Lordship
When-
will decide. I will not
when
argue
will
on the
you
on
address?
case, Lordship.
You have to only find out material.
Yes, I will not address him.
Take some more time. On Monday is, no, you have to find out. Because
Not so where we pay local, that's the only difficulty. These are going to be.
okay, let it be on Monday. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that he has to go through the scanned copies of the records of the trial court before answering the queries posed by this court during the course of the hearing. Let this matter be listed on 30/9/2024 as part heard matter.
Upload.
You are on interim. Yes. Heard Mr. S. Das.
Chaudhary.
S.
A. Chaudhary.
A.S.
Chaudhary.
A.S. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed Wait,
29th of
on 29th October. The interim shall continue till next day. Interim order shall continue till next.
22 and 23 also, their CD was there, updated CD was controlled. Is not received from Rathavadi.
What in which?
They are on interim level.
You are on interim bail.
My lord. May I please your lordship? I understand my lord CD is not there, my lordship. So I have my lordship, two submissions, my lordship. Because the interim order passed on 25/6/2024, my lordship. My lordship, initially this cryptocurrency was banned by the Reserve Bank of India, my lordship. And
Banned.
after banned, completely banned, my lordship. And after the judgment of the Supreme Court, my lordship, Internet and Mobile Association of India, Reserve Bank of India, 2020-10 SSC, page 274, my lordship, this ban was lifted, my lordship. So, my lordship, at this juncture today, my lordship, the cryptocurrency is not banned in India, my lordship. Neither is declared illegal, my lordship. Moreover, my lordship, one more
No.
submission.
Going by that submission.
Yes.
When the offense is alleged to have been committed, whether at that time it was banned or not, only that will be considered.
My lordship,
Suppose later on the ban is lifted, you may not get benefit of that.
my lordship, it was lifted on 2020, my lordship. Lordship, I have brought the judgment, my lordship.
And when your offense is alleged to have been committed,
My lordship, kindly see the FIR at page number.
okay, anyhow,
No,
the
my lordship.
case diary is not there.
Moreover, my lordship, this case is because of this IT Act, my lordship. There is an overriding effect, my lordship, section 81, my lordship. My lordship is well aware of the effect, my lordship. Once section 81 overriding effect is there, my lordship, the IFNC offences are over. Is gone, my lordship. So it's become a bailable offense, my lordship. So interim is there, my lordship.
Amount is.
Made it absolute, my lordship.
55 lakhs is.
No, what was the allegation? What
My
he
lordship,
did?
this is important, my lordship. Page number 9, my lordship.
No, CD has to,
Yes, to
but what is the offense?
my lordship, I dealing with the cryptocurrency. I am only the introducer, my lordship. And anyone can do cryptocurrency, my lordship. Even I
No,
can.
what you do?
My lordship, I am a businessman. I am also an investor, my lordship. And nowadays, people are doing cryptocurrency is very common, my
No,
lordship.
doing cryptocurrency means what? What you are
Cryptocurrency, my
actually
lordship, is a
doing?
kind of digital currency, my
No,
lordship.
okay, but how you are dealing with
My
cryptocurrency?
lordship, if I go to Google Play Store, my lordship, one can download this Binayak app stores. From there, one can invest money there, my lordship,
Okay,
in a digital form, my lordship, and he can sell it, my lordship.
what you did in this case?
In this case, my lordship, I have not invested the informant money, my lordship. He has invested himself money, but through his mobile, my lordship.
Where?
In the cryptocurrency, my lordship. There is an app, my lordship. In that app, Bitcoin, my
In a
lordship.
particular app,
He
he
has
has
invested.
invested money
My lordship, my lordship.
and he suffered loss.
He suffered loss, my lordship. And now,
How you are involved?
because I told him this is a profitable business, you can do it, my lordship. Now friends are gossiping everywhere, say yes.
This is 55 lakhs is the money. You-
Okay, let the case diary come. Heard Mr. F.A. Laskar.
D. Hussain, my lord.
Heard Mr. B. Hussain.
D. my lord.
D.
D. Hussain for item number 23, my lord. And 20,
Now 22.
Okay, both are same cases.
both the same case, my lord.
Item number 23, 22, heard Mr. F.A. Laskar. And in item number, same order hobo, council bile hobo. Also heard Mr. K.K. Parashar, learned additional public prosecutor who submits that the case diary, he who prays for some more time for producing the case diary, prayer is allowed. When can you produce?
5th of
Let this case be listed on 5th of November for case diary. The interim order shall continue till next day
Highly obliged.
in both the cases,
Except 5th, madam.
except
5th. 6th one.
6th of November.
Highly obliged, my lord. Grateful.
Ma'am, please. My lord, we have taken a justice service, my lord, and I have filed my affidavit. Lordship will see the flag B, my.
upon response number 9 and 10.
There is no flag B actually,
My lord, I have seen the record, my lord, on the notes, lordship will see.
the flag A.
D. Next, my lord.
B is not there.
Last page salon, air pieces salon. Which have been filed on, my lord, 29/24. Filed by one of my junior L Mohan. I have checked it, my lord, it is there.
When it was filed,
29/23.
on respondent number 10 and 9.
My lord, 9/10. That's the service. And we have obtained duly acknowledgement, my lord, putting signature at page 118 and 119.
In page 118, no signatures. are
Yes,
there.
it is there, my lord. That's true, my lord. Also, can they have a look here? Seal and sign.
Digbo Municipal Corporation.
Yes, my lord. Digboy Town Committee, Digboy, and Chief Executive Officer, Digboy, Town Committee, Digboy, Tinsukia. And they have put, my lord, their seal also with signature.
Mr. J.I. Bordhuya. London. We will fix it for admission hearing.
Man, on that day, it can be disposed of, my lord. Very small issue, my.
Heard Mr. J.I. Bordhuya, learned counsel for the petitioner. Also heard Mr. A.K. Gupta, learned counsel for the respondent number 1, 2, and 3. Learned counsel for the petitioner has submitted that the petitioner has filed an affidavit regarding service of notice through Dusty mode on respondent number 10 and 9. Stop. I have gone through the said of his affidavit, which is accompanied by which is annexed with a copy of notice issued by this court, wherein seal and signatures of the addressee are also appended to. Stop. In view of the above, the notice issued to respondent number 9 and 10 are held to be duly served. Stop. Let this matter be listed for admission hearing after puja vacation on a date to be fixed by registrar.
My lord, lordship can fix the date, my lord. Lordship can fix it, my lord, on 24th or 25th October.
On 25th October.
That will.
27.
No.
Wait, please, sir. But this is an application for condonation of delay in filing substitution petition. Lordship,
How many ayes are there
3 ayes
for?
for
Even for the-
setting aside abatement and for substitution of legal aids.
When the, who died?
That the sole appellant,
Sole appellant died. When he died?
he died on 14/8/2017.
When this setting aside abatement application has been filed. This has been filed beyond the period of limitation.
Lordship.
An application would be required for condoning the delay in preferring the application for setting aside abatement.
Lordship.
Then only we can go to others.
The present application for substitution of delay
Substitution,
in filing
question of substitution will come later on. First, the abatement have to be set aside.
Lordship, my prayer is that whether the present application for condonation of delay in filing substitution petition is required. Present application for condonation of delay in filing substitution petition.
No, first you have to condone delay for setting aside abatement. Thereafter, we can go into other aspect. Now, actually the appeal has been abated on death of. So you have to come for setting aside abatement within the period of limitation. Is it or is not it?
Lordship, I may be permitted to file.
Okay, heard Mr. M. Talukdar, learned counsel for the applicant who prays for some time for filing appropriate application for condoning delay in preferring the application for setting aside an abatement. Also, heard Mr. You're for? Mr. A.J. Soikia for respondent number 1. The prayer is allowed. Let this case be listed after puja vacation on a date to be fixed by registry. In the meanwhile, the applicant may take appropriate steps as mentioned by him. List accordingly.
Item 30 from the appeal is
Judicial note counsel. None has appeared for the petitioner on call in 27/3/2020. একটু ভিতরে দিন। I'll dictate in chamber.
Lordship, here my evidence has been closed and that has not been accepted, Lordship.
I'm appearing for respond number 1 to 6. 1 to 5 is standing council of elementary, and 6 was the 10 district elementary education office. 1 is back, my lord, fixing a time frame in the cost.
Reasonable cost. Lordship, here, what happened, Lordship, the evidence was fixed on 3/1/2018, suit of 2017. Issues were framed on 10/11/2017.
Issues were framed on
10/11/2017.
and then
3/1/18 is the date fixed for PW. 3/1/18.
yes.
Then on 24/1/18, I prayed for adjournment. 8/2/18, the PO was on leave. 5/3/18, another adjournment as last chance, and 21/3/18, adjournment allowed with cost. Then on 5/4/18, I filed again a petition for adjournment, which was rejected. Thereafter,
Against that order you have.
that order also, thereafter I filed a petition under 151. And along with that, I also filed the evidence, Lordship. That was rejected. Against that, I have come, Lordship.
Where is the impugn order?
Lordship.
Then what is the fate of the suit? Suit is stayed.
To this state,
Okay.
they don't have control here.
Page 42 is the impugn order.
Lordship, Lordship. It held that under 151, I cannot review.
This suit is for
Claim for damages, because he claimed that he has been wrongly placed under suspension. Lordship, what happened in this case, Lordship? He was working as an in-charge headmaster and
against government.
his government, specifically under private, two government official who has been added as private response by name, Lordship. That he has been wrongly placed suspension because he was empaneled as a headmaster and working as an in-charge headmaster. Then respondent number 7 has been brought in there as a headmaster from a different school. That order is stated to be passed on, Lordship, 15/9/14. But however, he approached for joining on 17/1/15. According to the plaintiff, this is a backdated order, and for non-compliance, he has been placed under suspension. That is the case. So for damage of reputation, he has filed this. Because ultimately it was withdrawn, but no proceeding, nothing has been started against him.
Now you are in service.
I'm in service. Lordship, I'll be relying upon two decisions.
Show me. What is this?
Lordship, 2016 1 GLT 519, I will be 11 paragraph is paragraph 5. One quotation from the Salem Bar case, Lordship, that paragraph 31 has been quoted down below. May I read that, Lordship? In some extreme cases, it may become necessary to grant adjournment despite the fact that 3 adjournment have already been granted. Ultimately, it would depend upon the facts and circumstances of each case on the basis of whereof the court would decide to grant or refuse adjournment. The provision for cost and
Now,
higher
what
cost.
is your ground? Why you failed?
I was not granted leave. I could not leave the school. That has been stated in the application. That application has been annexed, Lordship. Page.
Okay,
38.
The next case,
The next is that under 151 that can be reviewed. 2009 5 GLT, Lordship, paragraph 14. Uh, 5 GLT 664. May I read paragraph 14, Lordship?
yes.
If an order has been passed by a court without hearing a party, it is within the power of the court to review such an order and give an opportunity to the court. That is not my case, which is likely to be affected by such an order to have a say in
But
the matter.
here,
Next line is important, Lordship. There is no provision in the court specifically prohibiting a court from reviewing its own order on its own motion. When there is no bar created by the court, it is open to a civil court in an appropriate case to take resort to inherent power, for the inherent powers are in addition to the powers specifically conferred on the court by the court. So, court could have exercised a power under 151. That is inherent in it. And Lordship here, Lordship, the substantive justice, that is the sole intention, Lordship. The procedural law should not come as a barrier to grant substantive justice. And if I am not allowed to lay the evidence, Lordship, whole suits fails, Lordship. So for the sake of that substantive justice, Lordship.
you are not opposing.
He has to succeed in trial, Lordship. Finally, he has to succeed in trial.
The order, but the difference on the part of the plaintiff in conducting the case is very apparent. It's not disputed. Logically,
No,
it's a time frame.
And some reasonable cost, Lordship. He deserves to.
Cost to be paid to whom? There are private respondents also.
Basically,
The challenge is against the state. Okay.
Like the state has unnecessarily been arrayed as a party. The main cause of action is against the respondent number 6, 7, and 8.
Probably the performer, their role will be performer also. Anyway, let him try his luck there. Whether his success will
Heard
not
Mr.
depend
B.
upon.
Chakravarti, learned counsel for the petitioner. Also heard Mr.
We are concerned about this already going on for 2017. This kind of cases, my lord, will set a time frame which should end within the next one.
Okay. Also heard Mr. K.K. Bhattacharya, learned government advocate Assam, as well as Mr. B. Kaushik, appearing for respondent number 6, respondent number 2 to 6. This application under Article 227 of the Constitution of India has been filed by the petitioner Abdul Karim Borbhuya, impugning the order dated 5/4/2018 passed by learned civil judge Hailakandi in money suit number 6 of 2017, by which the petitioner by which the petitioner's prayer for adducing evidence was rejected and the suit was fixed for defense evidence. The facts relevant for consideration of the instant instant revision application is that the petitioner had filed a money suit which was registered as money suit number 6/2017, claiming damages against his illegal suspension by the respondent authorities. The said money suit was fixed for. Where are the facts? Fixed for adducing evidence for the plaintiff side on
Lordship, on 10/11/17, it was fixed for issues.
no after issues where
Then it, for evidence, 3/1/18,
for the first time
for the first
on
time.
3/1/18 after framing of issues.
The next date was 24/1/18.
The next date in the suit was fixed on 24/1/18
And thereafter on 8/2/18.
and thereafter on 8/2/18, 5/3/18 and 21/3/18. On all the aforesaid dates,
I prayed for adjournment.
the petitioner had prayed for adjournment, which were allowed.
On 5/3/18, it was allowed with cost.
Stop. It is pertinent to mention herein that on 5/3/18, the trial court allowed the prayer for adjournment of the
Well, the
petitioner.
5/3/18 was last chance. 5/3/18 was last chance. On 21/3/18, it was allowed with cost.
No, instead of 5/3, right, 21/3/18, the prayer for adjournment of the petitioner was allowed with cost of rupees. How much? Where is the order dated?
Lordship, I'm the order is not.
Not
The
in.
next Lordship.
How we will know? Records were not called for, no?
Records are no.
Okay.
Lordship, 300. I have that certified copy, Lordship.
Cost of
Cert-
rupees 300 only. And the next date was fixed on 5/4/2018. However, on 5/4/2018, the petitioner again failed to adduce evidence and filed a petition bearing number 1504/2000 filed a petition praying for adjournment, which was rejected by the trial court. And next date was fixed for evidence of defense witnesses. No, evidence of defendant's witnesses on 24/2018. Stop. Thereafter, the petitioner filed an application under
Order 17.
17 Rule 2 of the CPC read with section 151 of this Code of Civil Procedure. Praying for vacating the order dated 5/4/2018 and giving chance to the petitioner to adduce his evidence for the ends of justice. Stop. However, by the order dated 28/3 on the said petition, before that, on the said petition, a miscase was registered bearing miscase number 27/2018. Stop. By order dated 28/3/2019,
19.
the petition filed by the present petitioner, was dismissed by the trial court on the ground that petitioner has
Taken several adjournments.
taken several adjournments, and under the said circumstances, taking the application under section 151 of the Code of Civil Procedure is not maintainable. Stop. Learned counsel for the petitioner has submitted that the petitioner was unable to adduce his evidence on 5/4/2000
Page 40, Lordship.
Page
40. The first paragraph at page 40.
What was the date when it was dismissed?
Dismissed on 21/3/19.
No. The
Earlier, Lordship.
earlier order,
5/4/18.
5/4/2018, as he was unable to, as he did not get leave from the school, and therefore he had to engage in counsel for pray for an adjournment on that day. Learned counsel for the petitioner has also submitted that the petitioner was not at fault on the day when the evidence for plaintiff side was closed, as he was not granted leave from the school on that day. It is also submitted that unless petitioner is allowed to adduce evidence in the suit, he would be highly prejudiced and his suit is likely to be dismissed for want of evidence. Learned counsel for the petitioner has also submitted that under the facts and circumstances of this case, the trial court erred in invoking its inherent powers under section 151 of the Code of Civil Procedure. By not allowing the application filed by the petitioner for reducing the evidence after it was closed. In support of his submission, learned counsel for the petitioner has cited a ruling of this court, ruling of a coordinate bench of this court in Sunil Kumar Surana versus Gajraj Surana, reported in 2010 AIR within bracket GAU 480, wherein it was observed as follows. Quote para 14. Learned counsel for the petitioner has also submitted that though order 17, how many adjournments you can take? 3 only.
3.
Though order 17 provides for order 17 rule 1 within bracket 1 provides for only 3 adjournments which may be granted to a party. However,
That is directory.
however, if the circumstances are beyond the control of the petitioner, the restrictions on the number of adjournments provided in the order 17 would not prohibit the court to grant an adjournment in an appropriate case. In support of his submissions, learned counsel for the petitioner has cited a ruling of this court in the case of Rekha Rani De Sarkar and others versus Dilip Roy, reported in 2016 1 GLT 519, wherein it was observed as follows. Quote para 5 from the judgment. On the other hand, learned counsel for the on the other hand, Mr. B. Kaushik, learned counsel for respondent number 2, respondent number 6, has submitted that the reasonings given by the trial court in the impugn order has justified rejecting the application made by the petitioner, and same may not be regarded as wrong reasoning. However, you are not objecting.
That may put him in difficulty, Lordship, despite his.
Stop. Stop. On the other hand, Government Advocate Mr. K.K. Bhattacharjee has also submitted that the proceeding of the money suit number 6/2017 was stayed by which order it was stayed? Stayed by this court by order dated order dated 20/12/2021,
2012-2020.
and as the money suit is almost 7 years, is an old case. In the event, this I can record that in the event it is allowed a time maybe, that is your submission. Okay. In the event the application of the petitioner is allowed, a fixed time may be given by this court for the trial court to finish the trial, preferably within a year. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record. It appears that though several opportunities were granted to the petitioner by the trial court to adduce his evidence in the money suit number 6/2017, and however he had failed to adduce evidence on several dates on one or other pretext. However, stop. It also appears that on 5/4/2018, when the plaintiff's evidence was closed in this case, in the aforesaid money suit, you took that plea that you were not
I
grant.
could not get leave, so I could not attend the court, Lordship. That is reflected in the application, Lordship. Page 40. Lord.
No, but on 5/4, you have not filed that petition.
No, it was filed on the next date to recall that order.
In recalling application, you
I
have
could not.
stated the reason that you could not take leave on 5/4. But on 5/4, when you filed the
That
application.
application is not there.
No, but in that application, you have mentioned some other reasons
Maybe.
that you could not collect papers. What was the last one? In the aforesaid money suit, as the ground taken by him that due to lack of relevant papers, he was not in a position to adduce evidence on that day, was not believed by the trial court. Stop. Stop. Apparently, it appears that the petitioner failed to convince the trial court on 5/4/2018 of having a reasonable ground to justify grant of an adjournment. And it appears from the order dated 5/4/2018 that the trial court was not wrong in rejecting the prayer for adjournment. However, in the impugn order dated 28/3/2019, the grounds taken by the petitioner in his petition 1833/2022 that he could not appear before the trial court on the date fixed for adducing evidence, as he was not granted leave by his school authority where he has been employed, has not been discussed in the impugn order. Stop. It appears that the ground stated by the petitioner in his petition number 1833/2022 was beyond the control of the petitioner, and it found, and regarding which no discussion was made in the impugn order. Stop. This court is of considered opinion that under the facts and circumstances of the case as discussed herein above, if the petitioner is allowed to adduce his evidence in the money suit, and if he is directed to pay reasonable cost for the lapses committed on his part, it would meet the ends of justice. Therefore, the impugn order is set aside, and the petitioner is, and the trial court is directed to allow the petitioner to adduce evidence on when
Next, Lordship may fix a date.
when will you appear? On
Immediately after Puja vacation, because now it will be Lordship. On 22nd.
22nd of October 2024. Stop. Subject to payment of cost of rupees. How much costs? Rupees 5,000. The cost shall be deposited in the government treasury. Stop. As the pending suit is a whole pending case of 2017, year 2017, the trial court shall make all endeavor to dispose of the case, dispose of the suit within a period of 1 year from the date of the from the date of the appearance of the petitioner before it, that is 22nd October 2024. Since the parties are represented before this court, the trial court need not to issue fresh notice to the defendants, and defendants shall also be represented before the trial court on 22nd October 2024. How you will adduce your evidence? By evidence on affidavit.
Evidence in the video.
So on that day, you will submit a
Lordship.
line majut likh diho. On 22nd 10/2024, the petitioner as plaintiff shall submit the evidence of all the witnesses which he proposed to adduce in the suit on affidavit. No further date shall be granted for the same to him. This civil revision is accordingly disposed of.
My lord, I'm just making some extraordinary prayer. I know the time is over. Lordship, in the morning I mentioned that item 28, I'm going to, no, 22, I suppose. 28.
Yes, 28.
Lordship, we want to withdraw, the appellant wants to withdraw it. I've got the instruction, Lordship, this email I'm submitting.
Okay.
And there was a I also, they had filed, Lordship will dispose of that, they can withdraw
This
that.
was part heard.
Part heard, lengthy heard. On two grounds only, Lordship. One is they argued on the income, Lordship, the service book. That was not with me, Lordship. So I checked the records, the service book
This
was
I was for
withdrawn.
But now if the appeal is withdrawn, Miller, then the entire award which has been awarded by the tribunal, that should be deposited with interest wherever they want it.
No, I asked him, he said ki here, I asked the criminal advocate, he said with registry. Already 50% with interest is deposited, we will deposit the rest within 4 weeks.
within to the registry or
No, wherever they want, like the claimant registry. We do not have any problem with.
no fifth.
As far as the award is concerned, it is 43, 38, 551. Totally, that's 38,551. And these has to carry interest as per the tribunal's order at the rate of 7% from 6th of April 2017 till realized. So naturally, we have not been paid anything.
No, already with interest, 50% with interest as per. High
What
Court order.
I propose to order, this appeal would be dismissed on withdrawal. The money already deposited,
Can withdraw.
they will withdraw from the registry. Remaining money, they will submit in the tribunal.
Tribunal.
But
4 weeks,
the
Lordship.
interest portion has to
No.
be clarified.
Interest we will pay, Lordship.
I am to get the money from the insurance company. It is regardless of the fact whether they have deposited it here or kept in bank or wherever.
No,
Because money
what,
is not with us.
no, what I propose, whatever is due to you, that will be according to the
Award.
award.
Yes.
That will remain. Out of that, whatever they have already paid in the registry, that shall be withdrawn. And whatever remains according to award, that the insurance company will deposit in the concerned tribunal
Okay. Within time, Lordship, 4 weeks.
within 4 weeks.
And Lordship, our statutory deposit may be, we may be allowed to withdraw that.
Okay, that order I will pass. So this appeal is dismissed on withdrawal with following observations. A report to Bhitar. I have a small dictation. Just a minute. Item number 28, logo. Heard Miss R.D. Majumdar learned counsel for the appellant. Also heard Mr. S. Datta, learned senior counsel assisted by Mr. M. Talukdar, learned counsel for the respondent. Stop. Learned counsel for the appellant has submitted that she has instructions from the appellants to withdraw the instant appeal. And to that effect, she has placed a communication received through email on 25 September 2024 on record. Let this said communication be placed on record. This appeal is accordingly dismissed on withdrawal. The registry shall disburse the 50% of the amount, awarded amount already deposited before the registry to the claimant respondent after proper verification. Stop. The statutory deposit of rupees 25,000 shall be returned back to the appellant by the registry. Stop. The remaining amount of the awarded compensation shall be deposited by the appellant / insurance company before the Motor Accident Claims Tribunal Kachar at Silchar within a period of 4 weeks from the date of this order. This appeal is accordingly disposed of. The interlocutor, in view of the Sahi Kihor Kande. In view of the orders passed in the MSC appeal number 112/2023 today, that is on 26 September 2029, this interlocutory application has become infructuous and accordingly disposed of.
I filed an IA, vacation of the increment. My learned friend is a revision petitioner. Your lordship last time wanted to dispose of some matter.
Now what is to be done today?
My prayer is to finally, because we finally dispose of, because there is a food park that has been blocked. That's why lordship, I can see it here.
Today morning, we have received the copy of their.
That
that
rejoinder, yesterday I provided, rejoinder.
You need some time.
Affidavit.
If possible, after
After statement.
No, unless you are prepared.
I am ready. But that, my lord, rejoinder, my lord, today morning I received that.
You go through the rejoinder. You take some.
Only 2 words I disputed, nothing else.
Let us start, my lord. I am the civil revision petition. No, I am ready.
No, this I is for vacation of the interim order. And the revision petition is for impugning which order?
That is
The order dated proceeds
25, 2025,
At page,
72. In revision petition 248,
in revision petition page
248, page 72.
248.
My
No, there
page
is
72.
page,
In CRP.
CRP, there is no 248.
CRP number,
No, case number 248, page number, what is it?
page 72.
What is this order? What it says?
My lord, the facts of
This
the-
has been impugned.
here in this
This is order passed under 151.
51.
What is that? What has been directed in this order?
Last paragraph, hence in view of the above discussion, this court deems fit to allow the prayer of the plaintiff petitioner directing the appeal
Not to make,
any further construction of the extended area until further orders. It is totally vague, my lord, that extended area, there is no any schedule. And it is not a part of the suit land. I am constructing a house, defendant.
Huh.
Constructing a house. And in eastern part, the suit land, the suit part, their suit is the right to use the path on my land. And eastern side, that is the suit land. In western side, I am constructing. And now by this, in the meantime, injunction has been granted, status quo has been given. And against that status quo order, I have filed appeal. That is another chapter. Now they have filed in petitions. In western side, they are using a part on my land that should be, they should be allowed to use that part. That is the application has been filed, and this the learned trial court has passed this order under 151. That is not the part of the suit land. Now, how under 151 it can be passed? Totally separate. If they have any grievance, they can file another suit. They can file order 39 rule 1 and 2. They can file an injunction petition. And this extended area is totally vague. How it is? There is no schedule, nothing. In their petition also.
okay, make your submissions. Let us. listen.
Plaintiff suit is for particular, that is schedule 1 and 2. And that is, my lord.
You are the
I am
plaintiff.
the defendant number 1.
You are defendant
Plaintiff.
number 1.
Plaintiff filed suit for right to use a path over my land on the basis of an agreement. That is their suit.
Okay. Use a path over which,
Over my land on the basis of an agreement. That is their claim.
okay.
That is the schedule 2.
The land is the schedule 2 land.
2 land.
Schedule 2 land.
Schedule
What
2.
is schedule 1 land?
Schedule 1 land, total land from northern to southern and eastern side also. There is L size, my lord, that is the part, total. Your lordship will be
No, what is the schedule
1 land.
1 land?
Yes, my lord. There is,
Who is the owner of that land?
I am the owner of that
Entire land.
entire land.
Schedule 1 land.
1 land and 2 land. And
And
they
schedule 2 land is a part of schedule 1 land.
1.
And over schedule 2 land, he is seeking a right to way
Right to.
on
right.
the basis of an agreement.
Agreement between me and him.
Okay,
That is their case.
yes.
We have denied that is another matter. Now.
Is he saying that you are constructing a building
Building
on the path,
on that part, schedule 2 land.
obstructing their right to
Obstructing
way?
the right to way.
Okay,
That is their bill. Then, my lord, they file injunction also. Accordingly, status quo was granted. And against that status quo, we have filed an
status quo over schedule,
schedule 2 land.
schedule 2 land, okay,
Against that, we have filed an appeal
Appeal.
that is pending.
okay.
In the meantime, now another petition has been filed,
Under 151.
151. And 151, they sought another way on the western side of my, that schedule 2 land, my western side of the total building. They want another part. And court passed this order.
Western side of which land?
That is my under construction building. That is the western side of that schedule 2 land.
Is it within schedule 2 land?
No. Schedule 2 land in western side, my building, under construction building. In that,
Over which land they want?
there is no
this?
schedule. Another land of my land. That is also my land. That is.
Where is
admitted.
their application under
My land,
151?
my-
page 66 to 69.
Yes. Let us read.
By the plaintiff has been instituted this suit with the prayer inter alia for declaration of right of use of himself and performer defendant number 2 and 3 over the first schedule path and for demolition of illegal construction over second schedule path, which is within first schedule, and for injunction, etc. The learned court has passed the order of status quo injunction petition relating to this suit, which is prevailing now. While stating this case, the plaintiff stated in para 12 of the plaint that due to such obstruction of the suit part, he along with his family members and the proper defendants have been using the vacant land of principal defendant number 1 situated on the west and north over the under construction RCC building for use of the same as path temporarily during the period of such construction. That the learned commissioner on being appointed by the learned court visited the first schedule path along with second schedule path suit and its surrounding areas in presence of both the contesting parties and submitted report, map and photographs. In the report, learned advocate commissioner also mentioned that plaintiff and performer defendants are now using said vacant land of the principal defendant number 1 as their path temporarily. That the principal defendant number 1 teach the plaintiff lesson.
You are the principal defendant
I am
number 1.
principal.
Okay.
To teach the plaintiff lesson, at first stage huge quantity of earth over said area, which the plaintiff and the performer defendants are using as their path temporarily for egress and ingress. From yesterday, the principal defendant number 1 started extending his said under construction RCC building also towards west and up to his northern boundary with RCC structure for which yesterday the mason and laborers of the principal defendant number 1 have dig huge hole of about 6 feet depth of to place RCC pillars thereon. And he also arranging to extend tie beam in ground level up to the said newly erected hole to connect the same with the said intended pillars. If the said pillars are erected and the tie beam is constructed, then the plaintiff and the performer defendant shall not remain any space for egress and ingress to and from their residence. The plaintiff has no other alternative path or places to use the same for egress and ingress. So the principal defendant also should be directed not to make any further construction of the said extended area till disposal of the suit. Otherwise, the plaintiff will suffer irreparable loss and injury. It is that learned court would graciously please to direct the principal defendant number 1 not to make any further construction of the said extended area till disposal of the suit.
Which is this extended
Nothing,
area?
that is western part.
Western part, is it within schedule 1 land?
No, that is my case.
It is not within schedule. It is.
It is separate.
Because the case of the plaintiff was that he was using a right of way on schedule 1 land.
1 and 2.
Schedule 2 land.
2 land.
Which is now put in status quo.
Yes.
So that way is now being used.
Yes.
The schedule 2 land is now used for right to way or not?
It is actually not blocked. Actually, that way has not been used by the plaintiff from earlier also.
Oh.
That is why status quo was given. The dispute was there. If they have any the advocate commissioner also might have assessed the land, suit land, and prepared a sketch also. I am submitting before your lord.
Where is that?
That is my lord. This rough sketch map. Or lordships, kindly see the first schedule land below it is written. First schedule land of the plaint. It is written A, B, C, D, E, F, C, H, J, K, L, M, N, O, P, Q, 8. That is written, my lord, which is the first schedule land.
that is marked also. And schedule,
What is DITCHN?
my lord, in north side, A, B, C, D, E, F, Z, that is straight way.
There is a ditch.
Yes, Z, H, I, Z, K, L, M, N, O, P, Q. This is the A schedule line. QA.
A schedule line is again, please read A.
A, B, C, D, E, F,
E,
F, Z, H, I, Z,
G, H, I,
Z,
J,
K,
K,
L, M, O,
L, M, N, O,
P, Q, A.
P, Q,
A.
L shaped.
It is L shape. It is the A schedule line.
This is schedule 1.
Schedule 1. And
Okay.
schedule Suitland second schedule, that is D from D.
From
D.
Where is D?
From north side. D, E, F, D.
No, just a minute.
File. One electric pole is written.
Yes, D.
D, E, F.
So it overlaps.
D, E, yes.
D, E, F.
F, Z, H, I, Z, K, L, M, O, P, Q. This part
L,
is
M, O, P, Q.
This is schedule.
Same line.
Same line.
Only the extension is A, B, C,
Yes,
and
that is L size, that is. And in western
so
side,
this land is excess A, B,
C, D, and
Q.
Q.
What is this land? This is excess land.
Access. That is a schedule and they are saying all.
And the
Now, my lord, and in western side, that is QP.
where is the right of way they are claiming?
Now in western side, path type land of principal defendant number 1 in left side, western side. And it is written for construction building, that is also marked.
Where is the land of the plaintiff?
Land of the in back side, that is
Back means northern.
means in northern side, right side of this schedule 1 land, entrance of gate, homestead of plaintiff in northern side.
Okay, what is your submission?
Now they want the path in western side.
Western means?
Western means it is written path type land of principal defendant number 1.
That is your land.
That is my land. They want this land now. That is extended area because these point that is our building points.
But this is not included in
No, schedule 1 and schedule 2.
schedule 1 and schedule 2 land. Okay.
Right. This is my case. If this is not a part of suit land, how they can claim for injunction? It is 151, it is also injunction. Restraining me to construct my house in western side. And
Yes, what is your case? There, his main contention is that the land over which 151 status quo has been granted is not the suit land. It is not identifiable. Only you have mentioned that is their case.
Plain, there is a page 21, there are plain.
Just a minute. Now, okay, before that, where the impugn order, the trial court has erred before that. One
That-
query
that-
to
that-
the counsel for the
Fine.
petitioner. Where the court has erred, where it has went wrong in the impugn order, what is the wrong in the impugn?
My lord, there is decisions of Supreme Court that no relief can be granted in interlocutory applications beyond the scope of this suit. Because the subject matter of suit is different. You cannot pass any interlocutory order beyond the scope of this. He has committed this, my lord jurisdiction.
Okay, what he should have done?
It's-
Just a query.
that should have been rejected, and they have a right to file a separate suit for that. And
Or
they
sought for an amendment.
sought for amendment also. Yes, that is also. Sought for
Okay.
amendment.
Okay, now you make your submission.
Okay,
Page 19. May I read the paragraph 10 of the plate? 10, 11, 12.
Yes.
19, paragraph 10. That during the first part of the appeal party, plenty is a member worked out of session some days by keeping their house in the law. After examining of the approach, the plenty found that the physical number one most individually constructed its slightly house on the southern side of the residential footpath. Plenty was south. The plenty inquired the physical number one, the word of such construction, who with the physical number one, take the work he had an urgent need of construction and will immediately demolish the same after the purpose of construction is over to the same. Then the principal division one started construction of an artificial house on the adjacent west to the second schedule. While the principal division number one started construction of the big artificial building, then there 7 feet vacant land on the west of the same under construction artificial structure, which is the axial breadth of the suit path now in existence. There is 7 feet breadth path situated in the west of the state under construction artificial building as the second scheduled suit path of this school. While the principal vendor number one started a construction, he stated that eastern boundary of the state artificial building will be confined to this land without encroaching in the land of suit path for its aerial portion. The paragraph 12 is important. That while the said RCP construction was going on, then the principal division number one allowed the plaintiff and the proforma division number 2 and 3 use vacant land situated to the west and north of the said under construction RCP building for give the same as part temporary uses for period of such construction. That is very important also.
No, where is this description of this land?
This description is lost in the
Is it
Advocate Commissioner report, Lordship.
No, is
By-
it second scheduled land? No.
It is alternative way. Second schedule part is all under the first schedule part. That schedule is Lordship will find page 22. Second schedule for is the part of the first schedule. That Lordship, after appearance of both the parties, defendant filed an application for local inspection report and my landlord placed the report. There is a place the statement, draft statement. There is a report of the Advocate Commissioner that is Lordship will find at page 17 of my IA. Advocate Commissioner report. That is very much important. My landlord friend is part of the case that page 17 of my IA 2630.
Yes. Why this local inspection commissioner was appointed.
They filed an application under order 39 for inspection of the school land area.
Okay.
Then court passed an order. Lordship, in case second paragraph about the idea conduct. Sense of plenty of the start of the members and the given number of and his members and Ramadan person of the nobility and the citizen players of the party. Then next thing Lordship will find top the plaintiff and the engaged lawyer identified and show the partially natural land of the plate by the different below and bottom was found page 18. During inspection, I found the school first sitting land as shown by the plaintiff as L pattern strip of land which started from the entrance gate of the front strip of plaintiff and extended up to a brief towards west and then taken turn towards south. The plaintiff abandoned the street land is their path for egress and ingress to their street. But I found the second scheduled street land is a strip of vacant and slightly low-lying land. On the northern side of the second scheduled land is the remaining part of first scheduled land of land. And the southern side of the same is an old Kacha house, almost in front of the entrance gate of the street of Langley. On the northern side of the approach of the footpath, I found a small beach full of water. The same beach has been partly covered with wooden planks for smooth egress and ingress of the street of Langley. Over the western side boundary land of second scheduled land, I found an under construction RCC building of London, number 1. The said under construction RCC building is constructed covering the second scheduled land. The said under construction building is shown by marking so and so. In the annex draft state map, northeast place, the southernmost portion of the RCC under construction building has been molded. The roof molded portion of the state building has been shown by marking here in the annex draft state map. Northeast place, I found 12 numbers of RCC pillars have been constructed up to the roof level of the state under construction building, which are connected to the roof level being the SRP marking part, that is northern portion of the state building has not yet been tied with upper level, only tied with the ground level. The means of the under construction building is filled with earth, but the second shoot land has not been filled with earth. On the eastern boundary of the second scheduled shoot land, I found other 2 numbers of RCC pillars in the alignment of the RCC pillars of the marking under construction building of the mission number 1. So the said pillars are not tied with lintel of the under construction building of the mission number 1, but I guess the same has been constructed as part of the same under construction building. I found an electric box stamp just touching the RCC pillars stamp constructed on the northeast corner of the second scheduled land. In the most portion of the second scheduled shoot land, I found Assam type Patka shop house at the division number 1. The division number 1 about that the said shop house has been given on them in front of the said shop house, that is in southern side, there is a veranda roof with rusty CIC. The said shop house of division number 1 is shown by Mercy so and so in the annex of statement. The western part of the said shop house falls over the western side boundary land against the The said western part of the shop house has been shown by marking so and so the annex draft statement not to escape. I found a signboard in front of the said shop house written as Joypuru Regiotar Work. New Coringa Silver Road, New Coringa so. The said shop house is old in nature. The said shop house has been roofed with CIC. The CICs of the roof, the roof houses also very old and rusted. the backside, that is on one side of the shop house, I found another kacha house which is partly fenced with CI sheets and partly fenced with bamboo split and also with CI sheet. The said kacha house is connected with the also marking Pakka shop house. The said kacha house has been shown by markings also the NS draft document. I found the feeling of the said kacha house has been bounded with whole Pakka ground level wall in the I found the CI sheets in the roof of said kacha house has become last and ruptured and the fencing of the said house was available. And defend number one, about the said shop house and kacha house have been constructed about 25 years back, about its own land, which can be even same on that. Plaintiffs are denied the above evidence for the one. I found some gap space in between so-and-so marking under constructed building and so-and-so marking kacha house of the item number one. And over the same gap, the molded roof of the under construction building is being extended with the support of cantilever. The molded portion of the said under construction building is item number one over the second schedule suit also supported with cantilever. I found from all sides of roof and the top of our pillars of the under construction building. Number one, iron rods are extended. On the further south of the above said shop house, number one, that is in front of the so-and-so marking shop house, number one, there is a back and both sides. What space under further South National Highway. The defend number one, that is defend number one, and this engaged lawyer showed me the part-time land of defend number one. On the western side of the above said so-and-so marking under construction building, which is connected with the National Highway in the south. The plaintiff and these members are also using the same part of the both land will go job that temporarily we are using that.
No. What is the submission?
Still two land. Still two land is the state part, which is within the part of deal one.
Schedule 2 land is the suit part.
Good part.
Okay.
Means the defendant started construction covering the schedule two part. Full obstructed me for egress and ingress to and from my residence. Then temporarily that's part we are keeping for the time being.
No, whether this path was used before filing of the suit,
Yes,
before filing of the suit.
before the plain paragraph 12 state.
So why have you not mentioned that in your plaint, mentioning it to be a suit land? This is also a disputed land. This land,
We are not claiming that part to be mine or permanently given to. There is an agreement.
understood.
between
You
that schedule one
agreement,
and there is not-
agreement was in respect of schedule 2 land.
Schedule-
But when he started constructing schedule 2 land, you started alternative path on the western side.
As per instruction of the defendant number one, he instructed for the time being, yes, I have read over the paragraph 10.
You use the suit, you use the land on the western side.
Western side as per his instruction. So for the time being, he will
But-
subsequently remove
But where have you mentioned that in your plaint?
that.
This
The
is
paragraph-
this is there in the commissioner's report at page 22.
Yes.
But where have you mentioned? His contention is that in the schedule land, schedule 2 land, which is a part of schedule 1 land. Schedule 2 land is bigger or 1 land is bigger? Schedule 2 land. And status quo was already granted by the
Injunction on the basis of Advocates Commissioner report, my lordship, that injunction petition is page 20, the order lordship. Page 20. Court consider the report of the Advocate Commissioner, then pass the injunction on the basis of report of the Advocate Commissioner.
What
Page
was the,
23
what,
of my IL lordship.
what was the order?
Yes, page 23.
No, what was the order?
Yes, order page lorships.
Ultimately, injunction was granted.
Yes,
What injunction was granted?
status quo given.
Status quo. So status quo means if they have constructed building, your case is that they have constructed building over that land.
Yes.
Now, who has challenged the order? You have challenged the order before the appellate court against the grant of status quo.
And when lordship, after status quo order was passed by the London trial court, they started extending area of their building, which we are temporarily using for the time being put as per instruction of them, and same has been also reflected in the Advocate Commissioner report. They started and constructing extending portion. It was initially not there. And then in the report also, they have also stated, number one, showed that path is temporarily used. Subsequently, after getting a status quo order lordship, they're extending his building. That's why I filed an application under section 151, my landing from the date of birth. That is page lordships 34 of my injunction petition.
Where is the building? In the sketch map,
Yes, sir.
in the sketch map of the
Right.
commissioner, where is the building?
Construction of building of different number one, that is TS. My lord,
TS.
TSR.
Just a minute. TSR,
PQ,
TSR,
Q.
Q,
P,
P,
E,
E, over schedule
our schedule. F,
F,
F, O,
O,
U,
O, U.
and T. T, from T started.
This is the portion over.
It is the under construction building.
So his allegation was over Q, D, E, F, O, A, Q.
Right.
This was the portion of
Of
the
second part of
second
second
schedule
schedule
land
plan.
over which there was construction,
That is there,
over which status quo has been granted.
already granted. Not only that, entire up to south. Enters north to south.
Okay, Mr.
Page 34 of my application under the one.
Putul, this is item number.
Page 34 of IL.
Yes. Now this 151 is not in respect of schedule A land or schedule 2 land.
Yes.
That you agree?
That's very deep.
No. Before
Yes.
Mr. Borgmeier,
Yes.
let us make it more simple. His case is your suit was with regard to schedule 1 and schedule 2 land over which you claim a right to way, and he had started constructing a building over a portion of schedule 2 land. On which, on your application, after perusal of the report of the commissioner, status quo was granted by the trial court. Against the said order, he has preferred an appeal under 43(1)(r) before the first appellate court. Now his case is relief which you are seeking under 141, 151 and which you got under 151 is beyond the scope of schedule length, beyond the scope of the suit.
This is the submission of my
And,
learned.
and they have cited a reason, ruling of the apex court.
Kindly see
You
the,
have to counter that submission.
that's page 38 of the imperial order.
38.
That will come. Court order ID. Page 38 of my ILO.
Yes.
By this order, I am going to dispose this petition number so and so filed with the plaintiff under section 151 CPC, praying to pass necessary order directing the principal defendant number 1 not to make any further construction of the extended area. The OP received the copy of the same objection, had granted counsel of both the sides.
Now this extended area, where it is,
Extend the
where it
part-
is identified.
part which we are using temporarily for the time being. That's extended.
But that was not the subject matter of the suit.
But that has been mentioned in the advocate commissioner report and trial court considered on that basis also that us. Since he fully covered my second schedule part, unable to use this. That is reflected in the advocate commission report.
Then you have to amend your plaint. Or without amending the plaint, without bringing in those facts. That is his submission. I am not saying that you have to do this or,
Meantime, whether they filed or that I have not also taken action.
but his main objection
Yeah.
is,
Why the court has passed under 151 law?
yes,
By
because this
invoking one-
extended area has to be identified.
That's what in the mark lawship identified. The commission report lawships in advocate has identified it.
Yes. Read, please read.
Page 22.
Page,
Page 22.
you were reading 38.
Oh, now I am reading, yes, for lawship, I do. I am referring the commissioner report. Thank you.
Commissioner,
Then lawship, in the instant case, lawship.
just a minute.
Each one was time. Sorry, lawship. Page 38 or 20, 22 top paragraph, commissioner report.
22 you have already read.
Yeah, yes, already lost in mind. Read about it. Then page 38 of the imperial order, second paragraph, middle first start.
In 20, say, suppose in page 22, the commissioner has stated that presently they are using this road on the western side. That is an observation of the advocate commissioner. But then, without amending your plaint, can you get a relief with regard to that land, mainly on the basis of advocates commissioner's report? Without you, there is being an amendment to your suit plaint.
Under trial court, by considering the golden principle of the injunction.
But
And on the basis
But
of report loss,
the-
that's why status quo grant. That means for the time being, we may be allowed to go.
no, but this judgment that relief in interlocutory application cannot go beyond the scope of the main suit. For that, you have to bring your interlocutory application within the scope of the main suit. For that, it may be required that you may have to amend your plaint, which you have, because they have not, according to your allegation also, done anything on suit Schedule 1 and Schedule 2 land, over which already a status quo is there. Your allegation is, it is beyond that land.
Lordship, let me just tell
Yes, yes, yes. Make your
parts
submission.
of the learned trial court lordship.
Okay.
Page
Read,
38.
read 38.
Middle portion in the instant case.
Yes.
In the instant case, in hand, the plaintiff stated that he along with his family members and proforma dependent have been using vacant land of principal dependent number 1, situated on the west and north over the same under construction RCC building. For use of the same as part temporarily in the.
This you have stated in your 151 petition.
The 151. And
Okay.
land findings is the court's lordship page 39, bottom law. Lordship will find. What middle question, though the connecting title, page 39.
Yes.
Though the connecting title suit in the instant in this case, the plaintiffs have prayed for demolishing the RCC structure made over the second scheduled part by the principal given number 1. But since the same cannot be accepted by the plaintiff for that ingress and egress, and the present part, that is the vacant land of principal given number 1, the only way which is used by the plaintiff and proforma defendant for that ingress and egress at this point of time, for ends of justice, be allowed for the time. On that count, lordship 150, Planetary Court invoked in 151. Inherent power to invoke lordship on that count. The same schedule to totally wrong. There is no wrong at all. And there are one police report also, they have not complied the status quo order with the lordship. That filed an application that police Planet Trial Court sought for police report. That's I have also NF. What is the report of the police of the lordship that was submitted to the Planet Trial? Page 45.
That is in respect of the first status quo order.
Yes. And first status quo. Page 45. Lordship 40. Page 40.
But first status quo order
Yes.
is under challenge.
That the reports of state they are totally flawed. May I read it? With reference to the above, I am gonna to report you that I have physically inquired the spot. I found that all ingress and egress path is blocked by the second party member, namely Altaf Hussain, Tapadas and others, by constructing RCC pillars and walls. During inquiry, I have served a copy of the time ordered to second party member. I told them not to make any further construction on the extent area in further.
Where is the police report? Page 40.
Page 45. Original report is page 45 and the journalist. Type copy is page 4. In a pending suit lordship, original code can apply under one section 1 to become very created last of this.
Yes.
Yeah, 1961. Code 218. Bodom Sem, purpose state of
Yes, Para.
paragraph 8. May I read?
Yes.
Section 151 of the code reads, nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary for the ends of justice or to prevent abuse of process of law. The inherent powers of the courts are in addition to the powers specifically conferred on the court by the court. They are complementary to those powers, and therefore it must be held that the court is free to exercise them for the purpose mentioned in section 1 of the court. When the exercise of those powers is not in any way in conflict with what has been expressly provided in the court or against the intention of the legislature. It is also well recognized that the Indian power is not to be exercised in a manner which is contrary to what different from the legislature.
No. It speaks that 151 can be exercised for the ends of justice. But whether
Ends
it
of-
can, whether it can be exercised in relation to land which is beyond the scope of the main suit, that is the question.
And for the ends of justice, another case.
Yes.
2013 11
Vera?
paragraph 13 11 is 296 para 13. Section 151 CTC is not a substantive provision that confers the right to break the release of anything. It is a mere procedural provision which enables the party to have the proceeding of a pending suit conducted in a manner that is consistent with justice and equity. The court can do justice between the parties before law. That may be.
Okay.
Another civil appeal number 57.
These two judgments are with regard to the ambit of 151 powers. But it still does not address, do not address the issue raised by him. That can it be invoked?
When ends of justice. So specifically the order itself, is ends of justice for the time being in, since I am unable to use the second. Or if lordship has the order may be granted to remove the that part, the second schedule, the first of area, other than that. We are unable to increase the negatives.
No.
That's why courts lordship exercise 150 for the ends of justice.
Then you have you taken any steps to bring that portion of land within the ambit of your suit
That
by making an amendment?
in the
In
plain
the,
itself.
in the ends of justice, it has passed an order.
That-
Now that you have to, whether you have to bring that within the ambit of your suit.
That in the suit paragraph 12, I have stated. Paragraph I have 12 taken. For the time being, I have given. There's the place already there. And that is the report of the advocate commissioner.
There are 12 of the,
Or the plane or the paragraph 12 or the plane lordship that is your lordship
at
fine.
page,
CRP that page. Lordship plane start from page paragraph page 15 of the CRP. Paragraph 12, page 19 of the CRP lordship. Page 19.
Page 19.
19. Paragraph 12. While the state articles are going on, then the principal dependent one allows the plaintiff.
Okay.
Second and put on the left and not the case under pressure from appeal, but give the case as part temporary. Give the period of suffering, not permanent.
Over this plot of land, 151 powers has been, the status quo has been granted over this plot of land. Para 12 land.
Yes.
Okay.
Another lawsuit is for lawsuit. Within April 5784 of 2022. Assembly civil number 70153.
This is. Yes.
Para
Para?
26. Section 151 of the CPC provides for civil courts to invoke their inherent duties law and utilize the same to meet the ends of justice or to prevent abuse of justice. Although such a provision is worded, this court has tempered the provision to limit its remedy only to certain cases. By certain procedural clarification, ensure that substantive justice is not arbitrary or hyper-technical. That part that as in 1961 is code in for of that of the earlier I have provided.
Yes.
Then instant petition is prepared under 227. The scope is very limited. When we time place the life of the 2001 8 2001 8
2001.
Estella Rabat Barsa done stage by the paragraph 6 and 7.
Yes.
The scope and ambit of exercise of power and jurisdiction by the High Court under Article 227 of the Constitution of India examines explained in number of decisions of this court. The exercise of powers under this article involves a duty on the High Court, inferior courts and tribunals within the bounds of their authority and receive their good duty expected or required by them in a legal manner. The High Court is not vested with any unlimited authority or directive all kinds of hardship or wrong decisions made with the limits of jurisdiction subordinate whatever. Exercise of this power and interpreting with the orders of the courts of tribunal is restricted cases of serious dereliction of duty and flagrant violation of fundamental principles of law or justice. Where the High Court does not interfere, the grave injustice remains uncorrected. It is also well settled that High Court by acting under this article cannot exercise its power as an appellate court or substitute its own judgment in place of that of subordinate court, correct and error, which is not apparent on the face of the record. The High Court can set aside but ignore the findings of facts of the inferior court or evidence if there is no evidence at all to justify or the finding is so bad that no reasonable person can simply come to such a conclusion which the court of tribunal has come. Then paragraph 7. This court in Ahmedabad, 2020, Yeah, yes, there are stated that the power under Article 223 of the Constitution is intended to be used sparingly only in appropriate cases for the purpose of keeping the subordinate force and tribunal within the bounds of their authority and not for correcting mere error. Reference also has been made in this regard to the case of Variam Singh versus Amarnath 1954 SCR Sonso. This court in Woodmore Raitan Oswald versus Swanson Sonso and in 1975 observed that the power of superintendents and Article 227 cannot be invoked to correct the error of that which only a superior court can do in exercise of its ability power and the court of justice, and that the High Court in exercising its under Article 227 cannot convert their in court of justice when the legislature does not confer the right to it. Thus, by this pronounced, the High Court clearly considers and Article 227 and particular. Then another issue was the bill appeal number P072 of 2020.
Yes.
Paragraph 14.1. Last page of it. 14 point. The scope and ambit of the jurisdiction of Article 227 of the Constitution has been explained by this court in the case of Stellar Award versus Political, which has been consistently followed by this court. In the recent decision this court in the case of Diamond Draft therefore, by exercising the power in the Article 227 of the Constitution, High Court has there within the parameters to exercise the power of the Article 227. It goes without saying that even while considering the grant of interim stay, belief in a real petition and the Article 227 of the Constitution, the High Court has to bear in mind the remedial jurisdiction of superintendent and the Article 227 of the Constitution. And therefore, while granting an interim stay belief in a restriction and Article 227 of the Constitution against an order passed by the National Commission, saying that only to transfer the result of the powers exercised in Article 227. Here is the case that alternative path, which is the ambit of the plaintiff and the reporter, and while passing the injunction petition, learned trial court granted status on the basis of the pleading and the after passing of the injunction petition. To teach a lesson to me, they started extension over the area which we are using temporarily for the time being. The learned trial court specifically stated in this petition for the ends of that.
Okay. For using that alternative
Alternative for the
path,
time being, since I
was there any agreement between
there's an agreement between in
only
respect
with
of
his scheduled one land,
and
1 and 2?
but as per his advice, and since he's constructing, he told me he will remove the part of the building after completion of work. But when they found they were extending the again and again, fully obstructed, then I filed the extent books, and that time he also allowed me. That is also in the claimed also under the commissioner. Since I have no alternative.
Now this vacant land which you have mentioned in para 12 of your plan,
Yes.
whose land it is?
It is his land.
It is his land.
Yes.
Okay. And you want only right to way
Only right here for the time being.
till the disposal of
He
the
is
suit.
disposal, nothing else. That is my.
Okay.
Rather than court specially stated on this, since I am unable to use the my.
Any reply?
My lord, so far para 12, my lord, we have filed written statement and already denied this. That
Simply denied. Agreement also simply denied.
You have denied.
Denied.
But commissioner has also
That is not.
stated
That
in
they are using this part.
this para 12 part,
How my construction can be restrained?
unless there is a suit
There is a suit. It is
or
my land,
unless
it is
there is an
admitted,
amendment.
any amendment. How they can restrain my construction?
He says that under 151 it can be done.
If there is an alternative provision, my lord, 151 cannot be.
Okay, let me decide this.
Fine.
Anything else?
Okay. That fact, if losses, that order is set aside.
You will,
Direction, my submission loss, direction may be given to the court below to remove the construction part of the second civil war.
with that, in respect of that plan, a status quo is also already there.
Order. That's why since I unable to use, that's why I trial court and so justice.
Okay, heard Mr. N. Hawk, learned, I am reserving this order. N. Hawk, learned counsel for the petitioner. Also heard Mr. F. U. Borbhuya, learned counsel appearing for all the respondents. The hearing is concluded, judgment reserved.
Obliged.
কেস বিলাক বেলেগকে এটা ফাইলে দিয়াৰ লগতে এখন নহলে মিসপ্লেস হৈ যায়। Now, I have M30 RSC. Last second. Just a minute. Yes.
May I please? Before starting my arguments, I'd like to narrate this facts of the case.
Yes.
What is the facts of the case, Lordship? In this particular case, originally, there is a title suit between the respondent number 1 group and respondent number 2nd group under Urban Area Rent Control Act. That is title suit number 266 of 96.
Okay.
Wherein the first group filed this suit against the second group on the ground that second group is a tenant and he's a defaulter, so he should be evicted.
Okay.
After knowing these facts, I being the owner of the premises and the land where the suit house is situated, I filed an application in title suit number 266 of 96. And that application for impediment was rejected by the Honorable Court on 6/12/2024, 6/12/2004.
Application for impediment by the present.
That's it. We have filed an application for impediments to narrate the facts that the house not belongs to respondent number 1 group. It belongs to me. and there is a fraudulent suit filed between them only to take over the property.
And this was rejected on
That was rejected by order dated 6/12/2004,
6/12/2004.
Exhibit 2 and 3.
Okay.
Hereafter, after rejection of my application for implement, I have filed a suit, separate suit, that's settlement suit number 402 of 2005. of 2005 for declaration of my right and interest.
Okay.
And ejectment of the defendant number respondent group 2 from the suit line.
So respondent number 2 group is in possession, that is,
They were according to me, they are in permissive position because they were evicted from earlier plot of land. They have been allowed to stay in my plot of land in the house
by
on humanitarian ground.
you have allowed
I have it.
permissive. What is the suit land?
Suit land is
Suit land
measuring,
or suit premises?
suit premise is situated in a plot of land measuring 1 bigha, 1 kata 6 litres.
This is tenancy in respect of land or a house.
In respect of the land as well as house.
Okay. Thereafter, what happened to your suit?
My suit was dismissed on the ground of limitation.
Limitation
On the ground of limitation on the ground, Lordship will kindly, I will place the record on the ground that the earlier there is a suit filed by me regarding
before
this.
this suit.
Earlier, I have filed a suit because it is under Gwalpara district. Gwalpara district is a permanently settled estate, your honors knows. That is why under the Gwalpara Tenancy Act, the land has been acquired by the government. All Jamindari Abolition Act, under the Jamindari Abolition Act, land has been taken over by the government from the Jamindar. After that, the Khotian is issued to the person who is occupation of the land, who are the tenants. That suit was decreed ex parte in favor of me. That is title suit number 618 of 67.
Of 67.
67.
That was decreed ex parte in your favor.
Yes, Lordship.
In respect of the same suit.
Same land, 1 bigha, 1 kata 6 lesa. Khotian number 593, tag number 924.
Thereafter,
Lordship, I have plenty compilation, Lordship, it better for you, Lordship. Next page of the judgment, Lordship will find.
these are cited rulings.
Lordship. From the page 1, Lordship, this is Lordship annex my junior in the first page. That judgment is thereafter I will place the judgment. RSA 68 of 17, Lordship, got it.
Yes.
I have narrated the whole things here.
Sequence. 618 is the first suit which you filed in respect of this same suit land, which was decreed ex parte on 23/11/1967. No, yes. Thereafter, this 266 suit was filed by respondent number 1 group against respondent number 2 group.
Claiming
Claiming
that
respondent number 1 claiming himself to be the owner
of the property.
Owner of the property.
That is why he filed a suit for ejectment of the defendant.
And in that suit, you filed an impediment application which was rejected. Thereafter, you filed a separate
Thereafter,
suit,
we have been compelled to file the suit. That is title number
402.
402.
Now, what happened in 40
Trial court dismissed the suit on the ground
limitation?
on the ground of limitation, stating that one quotidian was prepared at quotidian number 5. Quotidian number 5 was prepared in respect of the land, present land.
Yes.
Quotidian was prepared in 1967 on Lordship. I will place the quotidian also. That quotidian was prepared in 1967. I have not challenged the quotidian at the relevant time. That is
Quotidian
why
in favor of showing
quotidian in favor
Respondent
of
number
respondent
one
number
group.
1 group. Quotidian number 5 was issued in favor of respondent number 1 group.
as riots.
Not as riot. They have claimed that one gift deed was executed in their favor by the original landowner, that is the Jamindar. After death of Jamindar, their wife has executed a gift deed in their favor in respect of many lands. And on the basis of gift deed, they entered their name in quotidian number 5. On that basis, they claim that they have a right. On the basis of a gift deed.
This quotidian was issued in the year
Quotidian was not issued in their favor. Their name has been entered in quotidian number 5.
when? When?
67.
And trial court said that you have not challenged this
The quotidian entry their name in the quotidian
within the period of limitation.
within the period of limitation.
Therefore, it is barred by.
Suit is barred by limitation. The appellate court has exceeded the jurisdiction and again declared right title and interest over the respondent number 1 over the suit land without any counterclaim.
On your appeal.
My appeal. Appellate court further exceeded the jurisdiction is a classic case.
That is title appeal number.
That is title appeal number. That is title appeal number 30 of 2014.
Referred by you. In this title appeal, your appeal was dismissed.
My appeal was dismissed, but his title has been declared. Title has been
His
declared.
title was declared.
Title was declared. Now I'll take your lordship to the plain initially.
Title of respondent number 1 group.
Declared.
Okay. Then against that, you have preferred this second appeal.
Second appeal.
What
That
was
the
the
finding of
substantial
the
before
trial
that?
court as an appellate court regarding point of limitation is perverse. I will place this text perverse and the
First appellate court.
first appellate court regarding
Declaration of the title of the
lordship.
respondent number 1 group.
Lordship.
No. Let us.
I will lordship and receive page 26
Of
of
the
the appeal.
memo of appeal.
Memo.
No, before that, before going to page 26, what substantial question of law was found?
Substantive question of law was framed on 6/3/2017. That is, lordship, the substitution of law is whether the finding of the appellate court so far as issue number 5 is concerned is perverse regarding title of the plaintiff on the face of the judgment and decree passed in title suit number 618 of 67. Exhibit 4 and 5.
Issue number 5 was?
Issue number 5, appellate court has declared title of the respondent number 1 group over the suit land in my appeal.
Okay, second is regarding
Second is
point of
whether finding of both learned court below in
limitation.
respect to the issue of limitation or purpose as same are decided without taking into consideration the materials on record.
Okay. Now page 20.
Now I'll take your lordship to the WS of page 23 of the contesting respondent.
Who is contesting? The respondent number 1 group.
Respondent 1 group.
But respondent number 2 is in possession.
Respondent number 2 was in position in the during pendency of the second appeal. There is an understanding and between the understanding on sale deed was executed in favor of another person, and they have been implicated in this particular case.
They are not contesting this appeal.
They have completed themselves as a party respondent in the second.
They are represented. They
They are
are
represented.
contesting.
They are represented.
Oh. You are the person who purchased it.
Our paper, as per that degree, we have evicted the defendant of group two.
And now you are in possession.
No, no, no.
In possession, purchase and subsequently arrest. So the land to a person, he was independent, I am representing him.
Okay.
I am the vendor and the purchaser.
Okay. So defendant number 2, who was the tenant,
No, defendant-
according to you, he was permissive possessor.
Permissive possession of myself.
He sold the land to
He did not sold also.
his wife.
Respondent number 1 group filed a suit against defendant number 2 group,
Yes.
declaring him as a tenant and eviction on the ground of defaulter. On the basis of that decree, that he is the tenancy case, this is not a case of right title and interest. This is a tenancy case, on the basis of which they want to take over the land. That is a collusive decree, and on the basis of that, they want to sell the land. May I clear also? They have filed a suit under the Urban Area Rent Control Act for ejectment on the grounds of defaulter.
Which suit? This
That is title suit number,
266.
that is title suit number 266 of 96.
260. That was decreed in favor of respondent number 1. Okay. After that,
They sold the land to another person. They have been-
respondent number 1 has sold it to another person.
Another person.
That another person has again sold it to another person.
No, no, no. They claim that they have sold the land to another person, and thereafter we have filed a petition before the injunction. There is an injunction order from this honorable court, and we have filed a petition for violation. These are on the record. I am not arguing because this petition, if appeal is heard, finally it will be decided by this honorable court. There is an injunction, so land cannot be sold at this stage, and that is they have admitted that they have not taken over position.
No, facts have to be clear. No.
On the basis of decree, they have this.
Now, before this court, the appellant is there. That is the plaintiff of title suit number 402, 2005 is the
Yes.
appellant. He is there. And this respondent number 1 or respondent number 2, anyone is there?
At present, land is vacant as per my.
No. Before who is contesting the appeal?
Respondent number 1 group.
Respondent number 1 group, as well as the person to whom they have sold
Sold
it,
it.
who has been impleaded as
Respondent in this appeal, second appeal.
respondent number.
Respondent number. They have been implemented as respondent number, I think, let's say, second group, that is respondent 6. Respondent number 6.
I am representing respondent number 1, 2, 3, and 4. Respondent number 5 are where the tenants, lordship.
They were originally represented by Bhomik Lordship. He is not appearing, he is not contesting case. VP Bhomik.
They have no position.
And who is representing respondent number 6?
Respondent number 6 is represented.
You are representing. Respondent number 6 claims to have purchased the suit land from the original respondent. Now you are in possession. According to your case, who is in possession? We means respondent number 6 or respondent number 1, 2, 3, and 4. Only 6.
The respondent number 5 were represented by Mr. VP Bhomik. They are not appearing as because the lands are already with us. We are the affected party.
This 1 bigha 1 kota 16 lecha land.
6 lecha.
6 lecha land is presently in possession of Javed Islam.
Rest with the vendor.
Okay, you have purchased 1 kota, 1 kota 4 lechas only. Remaining is with respondent number 1.
According to them, but it is not.
No, let me understand. There is
Five one IA, is that for that IA lordship.
You have been implemented.
The applicant has purchased the land area of 1 kata 4 lakh covered by so by executing mutual.
How much remains with respondent number one group?
1 kata 4 lakh purchase and in respect registered dated by so.
1 bigha 2 lecha.
1 kata 4 lakh and in respect of 18 lakhs of land and 17 number so in respect of land measuring 6 lakhs. Not sure, I have purchased 1 kata 4 lakh. So 18 lakh and 6 lakh will become 24 lakh. So 1 kata 4 lakh I have purchased.
And remaining land out of this 1 bigha 1 kotha 6.
I have 1 bigha 2 lakh.
I means
Vendor.
you are representing the vendor also.
Both.
Vendor and my purchaser.
So 1 bigha 2 lecha is with vendor means respondent number one group. Respondent number.
Then together were main party.
Okay. Value Sahid. There. Okay. Now this is the facts. Yes, Mr.
Now I take a look to the page 23, the WS. What is the stand in the written statement?
WS of respondent number one.
One group.
Just a minute. Value Sahid. WS is against filed by Imanus Sahid.
Lots.
But here the respondent number one is Wali Sahid.
Lots. Wali Sahid.
Wali Sahid is the defendant number 2 in the original. Your lordship may kindly go to page 17.
Just a minute.
Page 17 is the original claim. Your lordship will find the name of the party.
Page 17 is the original title suit. Title suit number 40205.
Value Sahid.
Defendant number 2.
Defendant number 2. Inamus is the defendant number 1.
Defendant number 1, but in present RSA, he was made as 4 legal heirs of late Inamus Sahid. Page 50, your lordship.
Okay, yes, defendant number 4.
Defendant number 1 becomes respondent number 4.
You are representing him also.
Also.
1, 2, 3, 4, all legal heirs and respondent number 6. Except 5. 5 is the group 2 defendant.
Who were the original tenant? Who were claiming to be tenant? They were tenant. Now land is not with them.
We updated it. So
Okay, okay, understood. Now yes, can come to page 23.
Page 23. That is a written statement filed by the respondent number 1 group. Now, page 23 also got it.
Yes.
Now,
Yes.
I will take your logic to para 13 of the WS, which is their claim, what is their right. They have described in para 13.
Para?
13, page 25.
Yes.
Logic got it.
Para 13.
Page 25.
Yes.
That the contention of para 8 is denied. It is denied that quotient number 5 is a fictitious quotient as it is. The quotient was prepared as per section 103 of GT Act, MNK 6 of 6162, where Noor
is
Nehar and
GT
other preferred petition for correction of record.
No, what is GTA?
GT Act is Gwalpara Tenancy Act.
Gwalpara Tenancy Act. Okay.
I will place that list. Noor Nehar Khatun and other preferred a petition for correction of record, erroneously showing their land as Khas quotient before Assistant Revenue Officer was specially appointed for preparation of record. The right after acquisition of Jamindari Act, who is authorized person under the law to inquire into the matter of correction of record, and accordingly ARO after the inquiry by his order dated 6/9/66 ordered the land measuring 1 bigha 1 kata 6 lesa covered by Dag number 924 of village Mankasar be recorded in the name of Nurun Nahar Hamida Khatun and others in Khotian number 5 of the village Mankasar Part 1 of rates are assessed at rupees 217 per biga, and defendant have acquired right by inheritance and deed of gift executed by the last owner by giving them possession by delivery. So basically, their right has been claimed on the basis of a gift deed, Your Honor. Your Lordship. Lordship got it?
Yes.
Light of inheritance and gift deed. This is very important, Lordship. They are not claiming right on the basis of tenancy, but on the basis of a gift deed executed by the original Lordship, the Jamindar, of wife of the Jamindars, Khan Bahadur's wife. And second stand, Lordship, will find page 27. Page 27, Lordship got it?
Yes.
Para 20. Plaintiff is not entitled for relief as claim. The plain where the land, Schedule A land, belongs to the defendant, and land is continuous possession for about 40 years by their own right, and the possession openly and adversely to all such plaintiff have no right, title, is not entitled for relief as claim in the plain. So they have two stands. One is on the basis of gift deed, they acquire title over the suit land. Second is by adverse possession.
Adverse possession. Okay.
So their right can be acquired. Lordship is aware that title can be acquired on the basis of two things. One is by title deed, that may be gift deed, that may be sale deed, or decree by a competent court of law. There is two procedure of getting title over a plot of land. That is, one is title deed. It may be sale deed, it may be gift deed, or any other instrument registered under the Registration Act, or by decree of a competent civil court. So they are claiming right over the suit land on the basis of a gift deed. On the gift deed, their name has been recorded in the Khotian number 5. Lordship is aware.
Yes, they are claiming inheritance and
Inheritance, gift deed,
and gift deed.
and adverse
Alternatively, adverse possession.
adverse possession. So Lordship is aware, Khotian is a document of tenancy. Khotian is not a document of title. That is a revenue record for acquiring for payment of revenue. And that is a for tenancy only. Gift deed or inheritance, Khotian is not prepared. Khotian is prepared in favor of tenant, not in favor of a owner by gift deed or any other document. Now, Lordship, I will take your Lordship to the evidence of the defendant. Lordship will find page 72. Page 72. Because page 72.
What is Khotian?
Khotian is a record of tenancy.
Record of rights
Record of tenancy.
regarding tenancy only.
Tenancy only. Because Gwalpara is a
That Khotian has been exhibited. In the,
Khotian has been exhibited. I will place that.
okay.
Now page 72, Lordship.
Yes.
The evidence of the DW. One DW has been examined by them. That is the 72, page 72.
Yes.
Now, Lordship, I will take your Lordship directly. What has been exhibited by them? Page 74. They have not exhibited the gift deed, Lordship. They have exhibited the order of the revenue officer, that is exhibited copy of the order 102, page 74. Lordship got it?
Yes.
That is copy of the order under section 102 of Gwalpara Tenancy Act.
Exhibit A.
Exhibit A.
What is 102?
Exhibit 102 is a provision for recording, filing application by tenant for recording their name in the revenue record
Got ya.
if their name has been left out after publication of the final record.
Okay.
Exhibit B is a copy of the final quotidian. That's it, got it.
Yes.
So they have not exhibited the gift deed. Why, Lordship? Now I'll take a Lordship to the why it is not placed. Lordship, in compilation, it will be relevant for your Lordship to understand the actual fact, why it was not produced. The compilation, Lordship, can this be the compilation?
Yes, page.
Page, Lordship will find page 23. It is judgment by this passed by this honorable court in second appeal by the respondent number 1 group. Page 23. Lordship got it?
Yes. This judgment was in the
RSA 18 of 2004 by respondent 1 group against another group on the basis of that gift deed. Lordship, kindly see page 27. Page 27. Lordship got it?
yes. No, whether this judgment was brought on record.
This is a judgment by this honorable court regarding this gift deed. That is why I'm placing, Lordship. This judgment is a judgment passed by this honorable court in a second appeal RSA of 18 of 2024.
Now, how it is connected with this?
Because the finding regarding the gift deed, because this is a in respect of the same land and judgment passed by this court by this honorable court regarding the same document is a relevant fact and that is binding.
No, whether it was brought to the notice of trial court or
because the gift deed was not placed before the trial court. Gift deed was not exhibited. I am placing for knowing the relevant fact before this honorable court. Lordship will finally decide the matter, but I am placing this only because the gift deed was not placed on record.
but
Why?
otherwise this judgment was not brought into notice
No,
of first appellate court
No, no.
or the trial court.
No,
Okay. This is judgment in RSA number
18 of 2004.
by
By Inamu Suit, Walis Shahid, this same person, respondent group.
against whom?
Against Lordship will find against Akhirul Islam, Rafiqul Islam, and Majibur Rahman and others.
Who are they?
They are also on the basis of that gift deed. Lot of land has been alleged to be sold. That is also record. Gift deed is not exhibited. That is
No,
on record.
I want to just understand. One of the party in RSA 18/2014, 2004 is party in this case.
Yes,
Also.
respondent number 1 group.
Who is the other party?
Other party
Is a stranger.
the in case stranger.
R1 versus stranger to this case. Okay, now what you want to say?
Page 27 Lordship, of the judgment.
Yes,
Lordship, middle portion, page 27, middle portion.
yes. From where?
Lordship, last portion of the para 5.
Yes, please.
According to defendant, Lordship got it, page 27, last paragraph, last
Yes,
paragraph of
yes,
5.
yes, according to the defendant.
Defendant Nurun Nehar gifted her property to Miam Muhammad Ilyas, predecessor interest of the defendant, and Hamida Khatun gifted the property to the defendant number 1 to 4. Thus, they become owner of the entire property. It would appear from that date of Hamida Khatun, in absence of any heirs, property owned by her devolved to Noor Nehar and Miam Muhammad in equal share. Therefore, Noor Nehar and Miam Muhammad Ilyas, surviving co-owner, got half of the entire property of Noor Nehar's respective shares. Plaintiff are claiming share of Noor Nehar, while defendants are claiming that Miam Muhammad Ilyas, in addition to the defendant claim based on 2 deed of gift executed by Noor Nehar and Hamida Khatun during their lifetime in their favor. It may be mentioned here that Exhibit Q is a deed of gift executed by Nurun Nahar in favor of Miam Muhammad Ilyas, predecessor of interest of defendant. This deed of gift was executed on 10/7/61. Exhibit Q is a deed of gift exhibit 8 dated 8 November 1968, executed by Hamida Khatun in favor of defendant number 1 to 4. 2 deed were executed prior to the settlement of land in favor of Noor Nehar and Hamida Khatun and Miam Muhammad Ilyas in 1970. Deed were executed when land was khas. Obviously, the donor at that point of time had no transferable right, title, and interest over the land except possession. Lordship got it. Because land has been acquired by the government. So after acquisition of the land, the Hamida Khatun and Noor Nehar has no transferable right except possession. The evidence on record appreciated by the learned first appellate court do not show that defendant at any point of time were in possession of the entire, therefore, they could not legally acceptable give right exhibit Q and Q want of delivery position. Now, finally, the finding has been given. Now, Lordship, I will take your Lordship. Why, Lordship, do we relevant fact?
Now, this RSA says that Noor Nahar could not have got title by way of
gift
after
because land has been acquired by the government.
Because at that time the donor was not having the
title. It has become a government land.
And in this case which we are dealing, the claim of the plaintiff, no,
claim of the defendant
in his WS was that Noor Nahar and Hamida Khatun
gifted the land.
Yes.
Along with their WS, they have enclosed the gift deed laws, but they have not executed the gift deed. That is the reason behind.
Or they have exhibited the Khotian and the order of 102 only.
102. Order of the 102.
Okay. Your case is that they were not having any title by way of gift deed.
That is why gift deed was not exhibited.
Because of the judgment in RSA 14.
Now, I will take your Lordship. What was 10? Lordship will kindly see exhibit. I have taken back the exhibit from the Honorable Court, original exhibit I have taken back. That is Khotian number 923. Exhibit 5. Lordship kindly see Lord Court record. I will give you. Page page 35 of the LCR. C5. C file has page 35.
Yes. Yes, page 35.
Lordship got it?
Yes.
LCR, C file,
This final Khotian form.
final Khotian. Lordship will find, I will give the original because there is a small photoset copy. I will hand over the copy, Lordship. Mokodama title suit number 618 of 2003 mote, Diera Siman Hukum mote, 5 nong Khotianot, 924 number
The
অংশত,
copy available in record is not very legible.
that is why Lordship, I will hand it over.
Okay.
I will hand over because it is small copy, photoset copy, it is the original. And Lordship will find in the original copy, there is a taken back by the plaintiff,
This is exhibit 5.
exhibit 5.
Yes, what do you want to show? No, you keep it with yourself. You may read out.
Lordship, I read out, Lordship. I've already read out. Next question. In left hand column, Lordship will find in left side, as per judgment and decree in title suit number,
618.
Lordship. My name has been recorded 1 bigha 1/6 acres of land on the basis of judgment and decree. In title suit number 618 of 67,
This is the ex parte order.
ex parte order. That is not under challenge by any party.
This was exhibited by you
Lordship.
as exhibit 5.
Lordship. Exhibit করা আছে না?
Yes.
And there is an endorsement, Assam Sarkar Sarkari, Lordship, in the exhibit 5, that is written that Assam Sarkar Sarkari, this land has been acquired by the government. And that is why in the original second appeal 18 of it, it has been recorded, this is government land, he has no right to sell the land. Give my executioner give it. Now I will take your Lordship to the document which has been exhibited by them, on the basis of which they acquired title.
Yes.
They have exhibited, Lordship will remember, the order of the Honorable Court under section 103 of Gwalior Tenancy Act. That is, Lordship will find exhibit A. That is in page number of the LCR. Page 53. Page 53 of the LCR.
Yes, this is the order sheet.
Order sheet. That is the Gwalior Tenancy Act 103 proceeding. Now I'll take your Lordship to the para 3.
There are 3 of
This order, Lordship. dated 6/9/65.
Yes,
This continuous order, which is executed by them, Lordship.
yes, please read.
To what relief? The passport office to be extended from the plaintiff Khotian. This joint petition of the plaintiff and Mia
No,
and
no, just a minute. Where are you reading?
the joint petition. Last but one page, Lordship.
Yes. The joint petition.
Lordship. Joint petition of the plaintiff and the Mia Muhammad Ilyas, that is the respondent number 1 group, on 24/165, making the same of the letter in Khotian number 5 above in place of plaintiff number 1 does not come under the purview of section 103. The transposition is stated to have been effected on 10/7/61, which is after final publication of the records. Very important also.
Okay.
Lordship, got it?
Yes, please read it again. The joint petition of the plaintiffs.
Joint petition of the plaintiff and Mia Mohammed Ilyas, dated 24/165,
Yes.
for making the name of the letter
For
in
mutating.
for mutating. Yes. For mutating their name in the letter in Khotian number 5. Lordship, got it?
Yes.
Khotian number 5 above in place of plaintiff number 1 does not come under the purview of section 103. The transposition is stated to have been effected on 10/7/61, which is after final publication of the records. Transaction is stated to have been effected on 1/7/61, which is after final publication of the record. The interested party may institute mutation case afresh. Lordship, got it?
Yes.
They claiming that on the basis of this order, their name has been entered in the Khotian number 5. By this order, they are claiming their name has been recorded in Khotian number 5. But this is not an order for entering their name in the Khotian number 5. What I have stated, Lordship, the Khotian number 5, their name has been entered fraudulently. That is what claim in the title suit. They have inserted the Khotian number name in the Khotian number 5 fraudulently. Now I'll take you to the Khotian. Khotian has been possible find in the Khotian, page 62. Khotian is not prepared on the basis of disorder. Khotian is prepared on the basis of give deed. Lordship will find in the first portion. Khotian is prepared on the basis of give deed. Khotian cannot be prepared on the basis of give deed.
Where is the order?
In the column, Lordship will first portion, Lordship will find on the basis of give deed.
Which column? There are many columns.
First column number, Lordship, I think Lordship 3. Assam Sarkar. On the basis of give deed, Lordship will find it. They entered their name not on the basis of 103 proceeding. They entered the Khotian fraudulently on the basis of a give deed.
Okay. Okay, from where you are saying that?
The Lordship, I will, if the Lordship handed over me the Lordship, I have not that document. I'll give the Lordship.
Name of Hamida and
Hamida Khatun is the original Lordship, Khan Bahadur's wife.
Nahar.
Noor Nehar and Hamida Khatun are the wife to wife of original Zamindar, Khan
Yes,
Bahadur.
Yes. Now, the dependent name is
Ilyas,
Ilyas.
Mian Muhammad Ilyas.
Danhotre.
Danhutre. Give it. This is a fraudulent preparation of Khotian that is under silence. They cannot acquire on the basis of that gift.
But there must be some order of the
On the
authority.
basis of gift deed. Khotian has been prepared on the basis of gift deed. Khotian cannot be prepared on the basis of gift deed. Lordship is aware.
No, before entering the name in Khotian, there has to be an order under 103.
103.
Where is that order?
I have already read Lordship 103.
That order is a different order.
That is exhibited by them on the basis of which they have recorded their name.
But here, the mention of that order has to be there in Khotian.
That is why Lordship we have stated, we
It
have
is
claimed.
Order dated 15/9/73.
That is 15/9, Lordship. 6/9/65. There is no such order. That is why they have not produced that order.
15/9/73.
Khotian cannot be prepared on the basis of a Lordship. Lordship will place the judgment. Khotian cannot be prepared on the basis of a gift deed.
No, gift deed may be a source from which they got their.
Khotian, if Khotian is prepared on the gift deed, not from the Lordship, the original landlord, that is the Zamindar. It may be by a tenant in favor of them. If tenant give a gift to another person, because it is a permanently settled area, Gwalpara Tenancy Act, it may be transferred by a tenant to another person by gift deed. Because here, the tenant under Gwalpara Tenancy Act has heritable and transferable right. Gift deed can be executed by a tenant, not by Hamida Khatun, original Jamindar.
Now, what is your submission? Here the name was mutated on the basis of a gift deed.
Executed by the Jamindar wife.
Okay.
Now, Clark's question is, Lordship, original trial court as well as the appellate court held that Lordship, the Khotian has been prepared in 1968. This name has been recorded in the revenue record. Fraudulently in 68 has not been challenged by me within the period of limitation. That is why suit is barred by limitation.
Now, your plea is that he does not give any title.
That do not give any title.
Therefore-
And in fact, that Khotian has been, Lordship, the revenue authority has cancelled this Khotian. I will place the order. We have evidence.
The trial court held that it is barred by limitation.
Barred by limitation, that their name has been recorded in Khotian in 68. I have filed this suit in 2005. That is why suit is barred.
And why, what was the observation of first appellate court?
First appellate court also held say the suit is barred by limitation in 68. Khotian has been prepared Indian name of defendant number 1 group. I have challenged in 2005. The suit is barred by limitation. And appellate court has held declared right title interest of the respondent number 1 group without any counterclaim, without any cause of action.
Okay. You have to give the points in writing also, your gist of your argument.
Yes.
Because it is a complex matter. unless you place your argument in it. I'm
Lordship,
taking notes, but still you have to give it.
Lordship, kindly take page 44, my evidence, what I have stated in evidence.
44 of the
Page 42 of the appeal note. Plaintiff evidence.
একটু হালকে রাখো কথা আছে ফাইনাল মাজত পৰি আৰু লিখিত থলে ভাল আছে because the records yes page
Page 42 is the Lordship evidence that now Lordship will find para 4.
page 47
How I have proved my title. Page 42,
42
Lordship, of the appeal memo, my evidence, type
Yes.
copy.
yes yes
Para 4, after date of my father, my mother, myself, and my brother filed a receipt number 618 of 67 against the state of Assam and obtained a decree on 23/11/67 declaring title and position for correction of record. Letter on record of Khotian number 593, Dag number 924, relating to 1 Bigha 1 Kotha 6 Lesa, Mankasa Part 1 was corrected on 25/169 in our name. In compliance to that, Lordship, we have proved copy of the plaint of title suit number 266.
now is it a case that in respect of the same land two Khotians are there exhibit A exhibit B exhibited by the defendant side which you are alleging that a fraudulent
Fraudulent
Khotian,
Khotian.
and the Khotian which you are mentioning in para 4 in respect of the same land.
Same land.
So,
Till date, my name is in the Khotian, I'm paying revenue.
so Khotian in respect of the same land, same plot of land, there are two Khotians.
And that Khotian is not in existence. That I will say
Which
from the
Khotian?
evidence. That Khotian exhibit B.
Exhibit 2,
Exhibit B.
exhibit B.
That Khotian is not in existence. That is a fraudulently prepared document in collation with the Lat Mandal. That was stand in your evidence as well as in the plain. That is on record. And that has been cancelled by the Revenue Department, Government of Assam. That is not in existence. So there is no question of challenging that.
No, but have you brought any evidence to that?
Lordship, that is why I will be giving the evidence.
Okay. But your case is that your name is also there in the Khotian.
Our
and
Khotian is 924.
924.
They included in Khotian number 5 this land. That is a fraudulent Khotian.
No, let me understand more. This Khotian was in respect of 1 Bigha 1 Kotha 6 lechas of land. Khotian number, Khotian which is exhibited as exhibit 2 by the defendant.
Exhibit B.
Exhibit B by the defendant. In
That is
respect-
Khotian number 5.
As exhibit 5,
No, Khotian number 5, exhibit B.
Khotian number 5 as exhibit B. And the Khotian which you have also exhibited the Khotian
Lordship.
as exhibit.
Exhibit 5.
Now exhibit 5 and exhibit B pertains to same plot of land. And your submission is exhibit B is fraudulent, not existing. it
Not in
was cancelled.
existence. That is a fraudulent Khotian. Fraudulently in the Khotian they have entered their name.
Have you brought any evidence on record?
Lordship. Now, Lordship, exhibit 4. Exhibit 4 is a decree in title suit number 618 of 67.
On the basis of which your name was mutated.
Lordship,
This was an expiry decree.
expiry decree.
Okay.
Quotidian number 593 is exhibit 5.
Exhibit 5. You are claiming your right on the basis of decree of a court. And you are claiming that your name was also mutated in
Revenue record as per
revenue
decree.
record as per the decree. Okay.
I have exhibited, Lordship, exhibit 12.
Yes.
Copy of the rejection order of the ARO dated 13/9/65. MNK number 178 of 6.
Exhibit 12.
Exhibit 12.
Exhibit sheet. Yes, this file. We filed to Logotheke. What is this rejection order?
Rejection order for ARO dated 13/9/65. Which I have already shown, Lordship. They have applied for recording their name in quotidian number 5. That has been rejected by the ARO. Lordship, I already have read the order. 13/9/06, 13/9/96. 965.
Okay, that is the order.
Lordship. Now, Lordship,
Where
they applied
were-
to enter their name in quotidian number 5. That has been rejected by the ARO.
why it was rejected?
Because it was after publication of the final record, revenue
They-
record.
They were suggested that you can file a fresh
Mutation
mutation
case. If that is, Lordship, quotidian is prepared on the basis of record of right of the tenancy. If give deed on the basis of give deed, they acquire the title, they have to file a mutation case.
Okay. Okay, what is exhibit 12?
Exhibit 12 is the ARO's order that Lordship, the rejection, there are implication in the name of the revenue record.
ARO's record you have read out.
Lordship, already read out.
Just a minute.
$13,965.
It is a page.
Page 53.
Okay. Yes.
Exhibit 13 is the order of suspension of quotidian number 5 by the DC Dhubri. Exhibit 13, they exhibit on the basis of quotidian number 5, they acquire title that has been suspended by the DC Dhubri. That is exhibit 13. And exhibit 14 is the copy of the letter by the Revenue Secretary to the DC Dhubri of the survey settlement and cancel the quotidian number 5 of Mankasar Part 1.
Whether this was brought to the notice of trial court and first appeal.
That is in exhibit 8.
But trial court did not
That
go
is,
into the.
that is why finding is verbose. That is the finding is verbose because they have said
It only
that I have to
decided the
challenge the
question.
quotidian number 5.
So whether is it a case that it decided only question of limitation and have not gone into these issues?
They said I have to challenge quotidian number 5. It was in 68. I have to challenge it in limitation within 3 years. I have not challenged. Their suit is barred by limitation.
Okay. But you have exhibited that this Khotian number 5 was all cancelled,
Suspended.
suspended. Now, what is the difference between suspension and
Page exhibit 13.
exhibit 13? Is page 49.
Only from giving the certified.
Certified copy.
But
Yes.
Satyan was not.
Ah.
The prayer was for giving the certified copy of that order by which the Satyan number 5 was opened and the documents. They applied for certified copy and that was.
Rejected.
That 5 for আদেশ মতে 5 নম্বর সতিয়ানৰ নকল দিয়া স্থগিত ৰখা হৈছে।
Oh, issuance of certified copy was only. Exhibit 5 was not suspended. Because on facts, you have to be clear.
No, no, what has been stated in evidence, I am reading the evidence also.
Oh, in evidence that was.
Projected.
But exhibit 13 says.
Exhibit, what he has stated may be correct, that this deputy commissioner has not allowed to take copy of the exhibit.
Certified copy.
Certified copy. And next is exhibit 13, letter from the Secretary Revenue Department to the DC Dhubri.
That is the exhibit.
Exhibit 14. Letter from Secretary.
Exhibit 14 is not there. Last exhibit is exhibit.
Exhibit and 13 and 14, that is a letter from.
In the list of exhibits. Last exhibit is the 13, exhibit number 13. There is no 14.
Lordship, I have the copy, Lordship, it may be in the record.
Into the open. Only 1 to 13 is there.
By us and 13 exhibit by.
Yes. The documents are very old.
Because it is a old case, Lordship.
You will finish today? Or
It will not be finished at 4:30 because I have to give the judgment also.
no? Actually, if it is listed within short period, I will remember everything.
Lordship.
And I want to finish it.
Lordship, that will be better.
Hearing before vacation, so that in vacation, the
Lordship can write it
judgment
down.
may be written. Tomorrow?
Tomorrow. I
Can be accommodated.
but our junior will be there, Lordship. If she will come free on free, she will come. The junior will record everything. What will say?
No. She has to be present because she has pointed out one thing. It
regarding
is
exhibit-
always helpful if we will.
Lordship may fix this matter tomorrow. If she is free, Lordship, she will.
or- No, no, you will get your chance.
Pointed out all these things.
Logically. Today is 25. and 26. How much time will you take more?
Tomorrow at 2 o'clock.
Okay, then we'll stop now. We'll take it up tomorrow at 2. Heard. Okay. And both of you have to give a gist of argument point wise after you complete your oral submissions. It will help.
I think this is the first, second, and out of records, we cannot argue.
Yes, we'll consider this. We'll confine ourselves only to the substantial question of law. But one of the substantial question of law is regarding perversity. So perversity, you have to go to all evidence.
And perversity should be within plain written statement.
And evidence on record.
And the evidence.
Yes.
Beyond that, we cannot.
So when the substantial question of law relates to perversity, then it becomes difficult for the court. It has to go into evidence also. Heard Mr. S. K. Goswami.
And Lordship also understand the facts of the case. That is why I'm directed the facts.
That is important. Heard Mr. S. K. Goswami, learned counsel for the appellants. Also heard Ms. R. Chaudhary, learned counsel for the respondents. The hearing remained inconclusive. Let this matter be listed again tomorrow, that is on 27/9/2024 at 2 p.m. as part heard matter. Should I keep it?
Lordship.
To record on the record.